मेंशन करना देंगे,
पता नहीं देंगे या नहीं देंगे सर आप
नहीं स्टार्टिंग में कर रहा हूँ
क्या करना है सर?
मेंशन करना
ये सर पता नहीं क्या कहेंगे।
नहीं
Some written submission.
हाँ रिटन सबमिशन करते हैं काइंडली अलाउड में Lordship, we have filed the written submission after the due date, so kindly allow the nodal officer to forward it to the court master and update in the portal.
But on the time period, this is a little scary because we have a suggested timeline of 12 hours and some 45 minutes. I don't think we have the luxury of time, not 12 hours. I don't think we'll be able to spend 12 hours on this.
Sir, humble
We were
It
hoping,
may spill over to tomorrow, my lord.
we were hoping that we'll complete it today, but if there's a spillover, we'll complete it in any case tomorrow.
Tomorrow. After the other 7, 9 and 10.
That won't take very long. They will
It's
just
more
have to pass
housekeeping,
procedural directions for, compilation.
My lord, so we take it that if it doesn't get over today, then after those 7 and 9.
Of course, yes.
This will continue.
Yes, absolutely.
The permissions to will not upload 4C and 5D. I mean 4C and 5D.
You want to add some volumes? What are they, Mr. Sakadande?
In 5D, there are 2 judgments. And in 4C, there are some enactments.
Enactments, yeah. All right.
Well, similarly, there are 1 or 2 other judgments which we want to cite.
Give them to the nodal council so that they can then, sort of put them together in the right place.
Look, may I also have liberty? My submissions, I noticed there's a mistake. I've just corrected that the wrong case has been cited. Maybe I have liberty to correct that.
You can certainly correct. Tell the nodal council, he'll replace it.
Well, then one more replacement that I would need is a typographical error that's kept into my written submissions. Well, I'll just email the correct version. Thank you.
Yeah.
Yes,
Lord, yes. At the outset, Lord, I will be dealing only with the Stamp Act and the Contract Act. To save time, my colleagues, Mr. Sathavende and Mr. Mehta will deal with the arbitration aspect. Then your lordship may decide the sequence, whether the amicus gets into it or Mr. Kambata gets in, the lordship may decide the sequence. But I'll take as little time as possible because focusing only on 11.6a, the Stamp Act and the Contract Act in that sequence. Now, my lord, I also wanted to mention that on the curative part, Lordship 7 judges will decide the main issue of the correctness of NNG2, and Global 2.
Yes, of course.
Yes. And then, my lord, whatever your lordship verdict, the curative can again go back to the 5 judges, then we will see what is to be done. That's my suggestion, my lord, because in this bench, I'm saying my humble request is let us not go into the curative part because we won't have time also on that. So
Because that may depend on the individual
yes,
facts,
I want to say
etc.
yes, because if your lordship sets aside NNG2, then there are certain consequences. If your lordship upholds NNG2, volume 1 of all these. Sorry.
Yes, Mr.
Yes. Now, my lord, volume 1 are the written
In our turn,
submissions.
my lords, we'll be addressing your lordships on curative jurisdiction. In our turn.
We are inclined as of now to send the curative issue to a bench of 5. We lay down the principle, correct, decide the correctness of NNG.
Anyway, your lordships will hear us. I don't want to interrupt the flow. I'm going to definitely address your lordships on this present jurisdiction which the court is exercising.
Certainly.
Yes. And my lord,
Yeah, that's very funny.
Lord, on the issue of curative, apart from Ashok Hura, my lord, lordship will also take it that there is one more judgment of Justice Dalbir Bhandari, Indian Council for Enviro Legal Action. But depending on what Mr. Shyam Devan says, I'll respond to that, Lord.
On to that and rejoin.
In reply, that's all.
Yes.
No, I'll straight away start. Lordship has got my written submissions, which is in volume 1. Now, my lord, the first submission I'm making is, if your lordship sees section 11.6a of the Act, Now, my lord,
Where do we get that in the,
Yes.
in the compilation? We
we
can
will be
also,
using it again and again, so take that.
it would be in volume 4,
Bookmark 9.
4A.
Yes. Take it. Page 1210.
Page 1220.
Yes. Lord, I want your lordship to notice one thing at the outset, that section 11 has a marginal note for appointment of arbitrators. And though the law is that marginal note may not necessarily control the interpretation, but it is definitely an aid to understanding the scope of the section. Just to set the record complete. Yes. As
Yes.
far as marginal note is concerned, I must just 2 minutes on the law. Earlier view was marginal note cannot be used in interpretation. That was the
That's
law.
not the view
That's not, in
taken.
2005, the House of Lords completely changed it and said that, look, definitely we can consider what is the scope of the section, what is the intention that's there.
And the reason in England was that a marginal note was never part of the original statute
Yes,
when it was
or the bill,
enacted in
yes,
Parliament.
Yes.
In India, marginal notes are part of the draft bill which is presented
Yes.
to Parliament.
In every finance bill, you'll have a marginal note also. So, my lord, let's take that marginal note. I'm just taking one
But
point.
it's not conclusive.
No, not at all. It's persuasive. Even Justice Subbarao and 59 said, yes, where there's ambiguity, we want to understand the scope of the section, we'll get it. But for our purposes, we can take, but it is discussed in GP Singh, 15th edition, at page 133 and 134. The earlier law is mentioned and the later law is mentioned. But due to shortage of time, I didn't want to get into that. My first submission is the section reads appointment of arbitrators. Now, if a lordship goes to 11.6a, 11.6a is a case where the Supreme Court or the High Court are considering applications under 3 subsections. That is subsection 4, subsection 5, and subsection 6. And lordship will find that in all these subsections, there is basically a deadlock in the appointment of an arbitrator. Either the parties cannot agree to it, or the 2 arbitrators cannot agree to a chairperson. Then, my lord, the court has to step in, resolve the deadlock and say, let not the arbitration procedure be stymied by this. We are appointing so-and-so and move on. So, my lord, my submission is the purpose of 11.6a is to remove the deadlock, so to speak, which arises, which necessitates an application in 4, 5, and 6. So that's the second point I'm making. Now, my lord, comes to the, sorry.
Yes.
My lord, now if your lordship comes to the main section 11.6a, which will be the bone of contention here. After referring to these subsections, lordship will note the very important point is a non-obstante clause, notwithstanding any judgment, decree, or order of any court. So obviously Parliament knew, as per the Law Commission report, S.B. Patel and the line of cases, where there was a duty cast upon the court also, not just to see the arbitration agreement, but to go further, see issues of validity and so on, because then they said that there is no point in referring a matter to arbitration which has so many defects. We'll clear it, some kind of a filter process, and then we'll send it. So they first say, notwithstanding any judgments, therefore the basis of all the judgments stand removed by the non-obstante clause.
It doesn't override any other statute though.
Pardon me?
It doesn't override any other statute.
No. Because there was no other statute coming in the way. I'll come to 33(2) later of the Stamp Act. And my lord, very unusually, the other point I'm making is that section 11(6)(a) jurisdiction is not an inherent power of the Supreme Court or the High Court. It's a confined jurisdiction. The jurisdiction has been confined by Parliament. And the contours of the jurisdiction have been restricted to examination of the existence of an arbitration agreement. Now, my lord, the statement of objects and reasons is set out in the Garware-Walrope's judgment, which your lordship will find in volume 5A. Now, my lord, volumes 5A and 5B contain all the cases, my lord, main cases. And if your lordship comes to the Garware-Walrope's judgment, volume 5A, it is in page 50. Lord, judgment starts at page 33 of volume 5A.
53.
Page 33, my lord.
Volume 5A.
5A. Now, my lord, this judgment has been followed in NN Global. And this judgment is relevant because it is the post 215 case. And if your lordship straight away comes to para 50.
Para 50.
Para 50.
Which page number in volume 5A?
Sorry, page 50. Page 50, para 13. Sorry, my apologies. My lordship will find, my lord, para 13. The statement of objects starts from para 6 if your lordship notes. My lord, if your lordship sees the actual statement of objects and reasons, the earlier paragraph mentions that India is 179 out of 190 countries in the index of doing business. This can't go on. Therefore, we have to simplify the procedure for ease of doing business. That's the earlier part of it. But now come to para 6 and subclause 4. To provide that while considering any application for appointment of arbitrator, the High Court or the Supreme Court shall examine the existence of a prima facie arbitration agreement and not other issues. So they have expressly mentioned not other issues. And that is very important when I come to section 33, subsection 2 of the Stamp Act. For the time being, Parliament is very, very clear. And lordship will note, they drop prima facie when the actual 11(6)(a) comes, but prima facie is continued in section 8 and in section 45. But the net result is the court shall confine itself to the examination of the existence of an arbitration agreement and not other issues. Now, lordship, where's my written submission? Lordship will also so therefore see the non-obstante clause, the word confine, and only to the existence of an arbitration agreement. Now, if a lordship just goes to section 7 for a minute, you can have three possible situations.
So we go back to,
Section 7 of the Arbitration Act.
we go to volume 4A, which we
4A.
opened up. And section 7. We have opened volume.
One 207. May I read?
Just one second. Yeah. Yes.
In this part, and Lordship will kindly see, arbitration agreement actually is defined in 2A to mean arbitration agreement means an agreement referred to in section 7. So the definition shifts the scope of the provision to section 7. So to be read with section 7 is the definition of arbitration agreement. Arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So, my lord, it's in this small subsection, there are numerous parts which my friends will deal with. So, arbitration agreement is to submit all or certain disputes. So, Lordship knows there are something called accepted matters, that some matters will not go to arbitration, which may arise in respect of a defined legal relationship. And this, the New Zealand court says, defined legal relationship is because we don't want to keep it very, very vague and broad. You should have a defined legal relationship. That is the point, whether contractual or not. So even if it's not contractual, and I can only think of, say, for example, a quasi-contract under the Chapter 9 of the Contract Act, where it creates a relationship of contract. That also is possibly covered with this. Now, this can be a simple vanilla clause where there's an arbitration, this is a basic contract which contains an arbitration clause, and that perhaps covers 99% of the cases where there is a contract between the parties, it contains an arbitration clause. But Lordship will now come to 7.3, 7.2. An arbitration agreement may be in the form of a clause in the contract or in the form of a separate agreement. So you can have a situation where the contract is a mother agreement, so to speak, and a clause is embedded in it. Or you could have a contract, it may have a separate. And I might just add, is whether contractual or not may also impact, like the case of chloro control, how far it extends to parties claiming under them and so on. So though strictly speaking, the other party may not be privy to the contract, but it still may be covered by the arbitration clause. But we are now basically concerned with stamping. Now, kindly come to an arbitration agreement shall be in writing. Now, 4 is important. An arbitration agreement is in writing if it is contained. So it's actually a deeming provision. 7.4 in my humble submission is a deeming provision. It is taken to be in writing in ABC situations. Lordship will just see a document signed by the parties. There is no dispute about that. Now, B and C create problems which are sorted by saying that if there is an arbitration agreement in correspondence, telecommunication, it is deemed to be in writing. Though the word deemed is not used, my humble submission is Parliament has created a legal fiction to say that an arbitration agreement shall be in writing if ABC. If it is contained in a document signed with the parties, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of an arbitration agreement is alleged by one party and not denied. So even by the rule of non-traverse, I don't deny the allegation.
Actually, the section 7.4 is inartistically worded. What they meant to say was not that it shall be deemed to be in writing, but that there shall be deemed to be an arbitration agreement if A, B, and C are fulfilled.
Yes. That there is an arbitration agreement, though the parties may not simply say that, Lordship, see what's the standard clause.
You need not have a contract where both sign the bottom.
And
A sends a letter to B, B responds by email or letter and say, I accept your proposal for an arbitration. It's an arbitration agreement.
yes,
Need not be in a formatted arbitration clause.
yes, like a template clause.
Yes.
It need not be in the template clause which says dispute shall be in arbitration. It will be governed by so-and-so rules.
I propose that all our disputes about price escalation and damages be referred to arbitration. The other party says, yes, I agree, subject to my counterclaims before the arbitrator. It's an arbitration agreement.
And the other issue which doesn't arise arise when stamping is electronic contracts, which I'll come to when I come to stamping. You can't possibly stamp the electronic contracts at the moment. I'll come to that. So my humble submission is, when you say arbitration agreement shall be in writing, now what is the duty of the court under 11(6)(a)? My humble submission is, if the arbitration clause is embedded in the contract itself, then the court does not need to do anything further than say, there is an arbitration clause. That's it. You please go ahead and whatever you want to say it before the arbitrators. But suppose one party says, I've got an arbitration agreement. He files a section, tells the other side, appoint an arbitrator. That party says, no, there is no arbitration agreement at all. Then you may refer to statement of claim, non-opposition, correspondence, telecommunication. That could be a Zoom call which is recorded. You don't know. So then the court will say, yes, there exists an arbitration agreement because of the nature of the correspondence, because of the nature of the telecommunication, correspondence, and so on. And in my humble submission, the role of the court stops there. And Lordship will kindly note that 11(6)(a), Lordship will note contemporaneously, or a bit late 2019 also. When 11(6)(a) was amended, the corresponding provision for international arbitration was section 45. And Lordship will kindly come to 45, where the duty of the court or the jurisdiction of the court is wider. And if your Lordship comes to page 4, section 45, page 1226. Thanks. Well, 26. There, the last part, power of judicial authority to refer to parties in arbitration, parties to arbitration, and notwithstanding anything contained in part 1 or the Code of Civil Procedure. Lordship will note here there is a non-obstante clause, quae statutes. A judicial authority, when seized of an action in a matter in respect of which parties have made an agreement referred to in section 44, shall at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration. Now this is important. Unless it prima facie finds that the arbitration agreement is null and void, inoperative, and incapable of being performed. And one thing, my lord, prima facie has been brought in 2019. Now, Lordship will note that when the Law Commission report, 246 Law Commission report came, they wanted to restrict the jurisdiction of the court under 11(6)(a) to existence and null and void. So Lordship sees the Law Commission report, that makes it very clear, and it is in paragraph, it comes in para 22 and para 44 of the judgment of NNG 2.
Volume and page.
Yes, volume. Take the page. 3 note will start. Just. Yeah, 302 at. Yes.
Volume
302.
Volume 5.
It starts at 302.
Volume 5.
And Lordship will kindly come to para 44, which is at internal page 57, which should be volume page 360, I think.
At page?
Yes, page 360. I'll just take. We'll go to page. Just one second.
360?
Just 1 minute. Let's pardon me. 358 of the PDF page.
Paragraph?
Paragraph 44. Now, my lord, The extract from the Law Commission report, the relevant part is para 33. Lordship, I'll just read 32. In relation to the nature of intervention, the exposition of the law is to be found in the decision of the Supreme Court in Shinetsu, where the Supreme Court has ruled in favor of looking at the issues / controversy only prima facie. Now, 33 is important and it has been italicized. It is in this context, the Commission has recommended the amendments to Section 8 and 11 of the Arbitration and Conciliation Act 1996. The scope of judicial intervention is only restricted to situations where the court / judicial authority finds that the arbitration agreement does not exist or is null and void. Now, my lord may kindly note, or is null and void is not added in the ultimate law which is made by Parliament. Null and void is there in 45, but null and void is not there in 11(6)(a). My humble submission is, if the Law Commission, sorry, my humble submission is, if Parliament had chosen to put in 11(6)(a) both existence and also null and void, then your lordship's jurisdiction would have been broader. But by deliberately deciding not to add null and void, they have further restricted your lordship the jurisdiction to existence. And this they further emphasize by using the word confine. So now, my lord.
And actually, when they enacted 6A, 6A came by Act 3 of 2016.
Yes.
At that time, in section 45, the word null and void was already in existence.
It was there. It was.
Except that prima facie came in 2019. Yes. So Parliament had before it the provision of section 45, where the power of the court was, in that sense, extended to determining whether the agreement was null and void. And they didn't follow that formula for domestic arbitration.
Correct. And also section 8. The lordship sees section 8. That also was much wider. This is existence of a...
There will be difficulty in accepting that argument.
Pardon me, Lord?
That section 8, the power of the court is wider compared to section 11.
No, I'm not saying...
Otherwise, fastest thing it differs, everybody will start filing petitions, civil suits.
No, at the moment, Lord, we only concerned with 11(6)(a) and Stamp Act.
There is some difficulty in this argument also.
Yes.
Existence something which is null and void cannot exist.
No, my lord.
So there is no. Parliament also, when it enacts, it does keep out redundant words. So won't it be better for you to confine yourself to the issue in question?
11(6)(a). Yes. Only my only submission, which I have to come to
relating
later.
to the Stamp Act.
Yes, Stamp Act. Only my submission is, which I'll just elaborate it later if necessary. In a landmark essay called Metaphysics of Nullity, where they say nullity and voidness are de jure concepts. An agreement can exist in fact, but it could be null and void in law. Like a notification which is ultra vires the act exists in fact, but unless it is struck down, it exists in fact, but not in law. But at the moment, I'll take a lordship's hint. I'll straight away go to 11(6)(a). So my submission is, no, I was answering my lord the Chief Justice's question.
No, that's fine.
No, what I'm saying is, when the draftsman sat down and prepared 11(6)(a), where is judicial intervention? What's the role of the courts? It's in section 11, it's in 8, it's in 9, it's in 14, it's in 34, and so on. So in the case of appointment of arbitrator, you have 11 and 45. 45 has null and void, here they drop null and void. So my submission is, if the agreement is null and void, still, my lord, the court can't go into this question on as far as existence is concerned, say, no, there's no arbitration agreement at all, it's barred by limitation. I'll come to that. Because howsoever the court may want to be a sentinel on the QA, so to speak, and filter out meaningless arbitrations, nevertheless, my lord, in the interest of the arbitration law itself, the court must confine itself to what Parliament says. Just see the existence of an arbitration agreement. Because 16 talks of validity. Lordship will see section 16 for a moment. The Lordship sees section 16. Give the electronic page.
Yes.
And if you to take a Lordship's thing, 45 is null and void, 16, page 1214.
Which provision are you referring to?
4A, my lord. All 16 is 1214, page 1214.
Arbitration. 121448.
1214.
Yes. Sixteen one
16 one.
at page 1214. And I'll go straight away to the Stamp Act. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement and for that purpose. So, my lord, this is there from day one, from the 1990s, from day one. It gives an hint that the tribunal has to see existence itself. If there's an arbitration existence, then it may have to go to the issue of validity. Because once the arbitration agreement exists, it may become invalid on so many other grounds. But there's an arbitration agreement. So existence and validity are basically two different concepts. S.B. Patel introduced validity at the appointment stage. And that was expressly rejected later. Doctor will find the S.B. Patel was noticed by the NNG 1. And there they say that no, we will not. S.B. Patel expressly says that we will go into validity also. The duty of the court is to go into validity. And that is then taken off by the amendment. And that the Lordship will find where S.B. Patel. No, where is it? Yeah, Lordship will come to 5A page. No, no. I'm talking of in NNG 2. Lordship will just bear with me for a minute. Just they refer to S.B. Patel, the extract S.B. Patel. Huh? Para 38. Page 355. Now, my lord, the extract para 12 of SBP, and Lordship will just come to about para 39, the italics portion.
Where are you reading, Mr. Datta?
Page 353, it starts para 38.
At volume 5A?
Yes, volume 5. Yes, Parag. Yes, Parag. And Lordship will just go to the end of the paragraph, which is on the next page, and just above para 39. The italics portion, Lordship has got the italics portion.
353, 354.
My lord has got the italics portion. We are inclined to the view that the decision of the Chief Justice on the issue of jurisdiction and the existence of a valid arbitration agreement would be binding on the parties when the matter goes to the arbitral tribunal and at subsequent stages, except in appeal so and so, so and so. So in this entire paragraph, they say the Chief Justice must
Just
also
one,
go above para 39. Yes, if your lordship wants, come to placetum B, my lord, of the same, in that same page. The question in the context of subsection 7 of section 11 is, what is the scope of the right conferred to rule upon its own jurisdiction? once the Chief Justice, etc. Then they say that at the appointment stage, under 11, the Chief Justice has to go into the jurisdiction and existence of a valid arbitration agreement. And once he decides that it's binding on the arbitral tribunal. Now, my lord, so I'll just say that as far as 11(6)(a) is concerned, in 2015, they have made it absolutely clear that you confine yourself to the existence of an arbitration agreement. Do not go into validity. Now, my lord, one more thing we should note, because whatever your lordship decides will impact the further law, because now they are going to delegate the power to institution. That's a proposal which has not yet been notified. Once an arbitral institution is to go into appoint an arbitrator, then that institution has no jurisdiction to go into the issues of other aspects at all. Right? They will simply appoint and then leave it to the arbitrator to decide.
So Datta, therefore, 11(6)(a) is no longer, it's been 2019 and now
It
abrogated.
has not been notified.
It's
Not been notified.
not been notified because of the institution not being.
Not being, yes, not being.
Otherwise, once the institutions are functional,
Yes. No, I'm saying that all that is part of a scheme.
there's no connect between institutionalization in the
No,
firm
what
which
I'm
is now
submitting is,
and the earlier enactment.
no, what I'm submitting is section 11 is the appointment stage, what you call the pre-arbitration stage or the pre-referral stage. Now, since your lordship asked the question, now there are clear distinctions. You can't appoint an arbitrator, therefore the arbitration cannot start. Court intervenes and says, Justice so-and-so or Mr. So-and-so is the arbitrator or the chairperson. You start moving. Then you go to section 16. Before 16, you argue on existence and validity. Now come to 34. I'm saying it's a full scheme. Existence is by the court. Existence and validity is by the arbitral tribunal. And the correctness of the arbitral tribunal on validity is
Then
part of the
second look is
limited
by the
judicial
court.
review under 34.
34.
Yeah, that's right.
So lordship sees 34(2)(a)(2). So if you now get into validity, you're really rupturing the entire scheme in my humble submission, because validity is left to the arbitrator. They decide the validity. The arbitral tribunal decision is not final. It's subject to judicial review by a 34 court. The 34 in bracket 111.222. Please come to 34(2)(a)(2).
That's fine.
Sorry. So lordship kindly sees the arbitration 34(2)(a)(2) arbitration agreement is not valid under the law in which, so that existence is not part of there, only the validity. And I'm just thinking to myself, lordship, I remember our law college days, my lord, we learned that all contracts are agreements, but all agreements are not contracts. That we studied in the law college. So I would say, my lord, use that analogy to say that every valid arbitration agreement exists, but every existing arbitration agreement need not be valid. An arbitration agreement may be there. And I'll come to Mullah's passage, which is quoted in this That's why when I come to contract, I'm going to point out the word void contract is an oxymoron. You can't say that, but I'll come to Stamp Act later. So, my lord, my submission is, I'll conclude my submissions on section 7, 11, 16 and 34 and say that validity has gone into the arbitral tribunal area subject to a check under 34 and of course to an appeal under 37 and 136. Now, my lord, let me come straight to the Stamp Act. How does the, sorry. Yeah. Where is that unenforceable? Yes, sorry. Number one, I'm coming straight away to the Stamp Act. And Lordship will come to page 394, volume 5A, which is the NNG2 judgment. And before reading it, my lord, I'll just give a broad overview of what I wanted to submit.
Page 394.
394 of volume 5A. This is the part of the NNG2 majority judgment.
390 volume 5A.
5A. I'm not going to read all the paragraph. I'll just show Lordship what the majority has held. And then I'll just come to the conclusion. Yeah, para 97. My apologies. I didn't see.
No, no, we apologize.
No, my lord, now just, I'll tell Lordship broadly, what is the view taken by the majority? What they say is the Stamp Act is a fiscal enactment. It has got its own importance. It's a source of revenue for the state. And under section 33, when a document is tendered which is not stamped or inadequately stamped, then the judicial authority or the holder of public office
Has to impound it.
has to impound it. Now, my lord, what is important is 33(2). And 33(2) casts a duty to examine, because as the lordship knows, it could not be stamped. It could be inadequately stamped. There could be very many situations. Is it coming under which item of the schedule? What's the quantum of stamp duty? Inadequacy. All these issues are there. That has to be examined in terms of 33(2). And what the majority says is that it is our duty. 11(6)(a) is a duty to examine the existence of an arbitration agreement. 33(2) casts a duty upon us to examine the correctness of the stamp. So both are in different compartments. The fact that my jurisdiction under 11(6)(a) is limited to examination does not mean that I cannot confine my duty to 33(2). And in my humble submission, that is an error of the majority, because Parliament has decided you don't worry about stamping in that sense. You just deal with the existence of an arbitration agreement. Stamping is a matter of validity. Stamping, registration, limitation, all this goes to validity. Let that be decided. But what the majority says is, the document is under our watchful gaze. And if we notice that the document is not stamped, then we necessarily have to 33(2). My humble submission is, even if under the watchful gaze you notice it is not stamped, under 11(6)(a), today you're confined to only existence of an arbitration agreement. The statement of objects and reasons stays, you will not deal with other issues. I don't mean to be disrespectful, but I'm just saying in a matter of speaking, what Parliament says is, let the courts confine to existence. All other issues, let it be relegated to the arbitral tribunal. Because ultimately, what is the purpose? The arbitration must be fast-tracked as much as possible. The judicial pit stops must be very, very limited. Under section 11 or 8, very, very limited. Let it go to arbitration, because parties have agreed that my dispute will be resolved by arbitration. And in Great Offshore, your lordship said all these are issues which interminably delay the arbitration proceedings: stamping, registration, validity, limitation. The court need not go into it. But just see the passages. In my humble submission, these require to be overruled, is my respectful submission.
Which is the paragraphs you want us to?
It starts at...
If you can just give us the paragraphs first, we'll make a note and then quickly breeze through those paragraphs.
Yes, yes. Lordship will just come to para 146. Now, my lord.
Paras which you think are important, so that...
So I don't need to read it, my lord. I'll just...
No, we'll read them, but if you can just tell us which...
Yes, para 146 from Placitum D. 146 are the contentions at page 394 of volume 5. Now, para 147 is important. Then, my lord, the final conclusion is at para 150, 151, 152.
Para 146?
146, 147,
150,
150, 151, 152.
152.
These are the important paragraphs.
These are the only paras.
The only paragraph.
And what about the minority?
My minority goes into the aspect, both Justice Rastogi and Justice Roy say that, look, it's not our concern to do that at all.
Give us just the paragraph.
I'll give the paragraph numbers later. Also. In fact, apart from this, Justice Roy goes into the aspect of Section 5 of the Arbitration Act. His lordship compares the unicitral model with Section 5. I'm coming to that. So I'll just finish 33.2. Please see 33.2. My lord, can I just read this paragraph first? Sorry, my lord. My lord, para 146 at page 394, my lord, in volume 5. My lord, lordship says the heading starts, section 33, and yes. The court or the arbitrator to act. My humble submission is Lordship will see at page 90, which is page 394. It's subpara alphabet O, and the question the court puts to itself is section 33 and 35 of the Stamp Act, the court or the arbitrator to act. And the court rules that the court has to act. And in my humble submission, that is against the mandate of section 11(6)(a), read with section 5 of the Arbitration Act. And I'll make good my submission in the context of 33(2). May I just read the paragraphs first and then go to the statutory provision? Now, please see para 147. Para 146 is the rival contentions. Now, please come to para 47. We see merit in the contention of the appellant. Apart from the court acting in consonance with the law, when it adheres to section 33 and 35 of the Stamp Act where it applies, in our view, under the watchful gaze of the court, be it the High Court or the Supreme Court, the issue related to stamp duty in a case where there is no stamp duty paid is best resolved. So this law is that when the court sees that there is no stamp duty paid, it immediately impounds the document and proceeds. Then, my lord, the question would arise as follows. A document containing the arbitration clause may not bear any stamp duty. We have already found that even in an arbitration agreement on its own may require to be stamped as submitted by the learned amicus. But then the court can proceed on the basis that the amount of stamp duty which the arbitration agreement contained an arbitration clause would be exigible to be extremely meager. There is very little likelihood of such an arbitration agreement not being stamped. Therefore, what the court is to consider is when the contract in which the arbitration clause is contained is not duly stamped, when it becomes the duty of the court to act under 33 and 35 of the Stamp Act. Then, my lord, they discuss the background of section 11(6)(a) SMS. I'll skip that with the lordship's permission. Now, 150. The question further arises as to whether, in view of the power of the court under section 11(a) to find only prima facie the existence of the arbitration agreement, it would enable the court to make a reference and appointment and relegate the issue of impounding the document to the arbitrator. In any shirking of the statutory duty by the court under section 11(a) to act in tune with the peremptory authority dictate of the Stamp Act appears to us unjustifiable. Such abdication of its plain duty is neither contemplated by the lawgiver, nor would it be justifiable as causing the breach of section 11(6)(a). Now, 152 is the final conclusion. The view that cases under section 11 would consume more time and hinder the timely progress of arbitration, and that the matter must be postponed so that the arbitrator will be more suitably deal with it, does not appeal to us. While the Stamp Act is primarily intended to collect revenue, and it is not intended to arm a litigant to raise technical pleas, this would hardly furnish justification for the court to ignore the voice of the legislature couched in unambiguous terms. We find that the view expressed in SMSTA states being reiterated despite the insertion of 11(6)(a) would promote the object of the Stamp Act and yet be reconcilable with the mandate of section 11(6)(a). We may, however, qualify what we have said with a caveat. There may be cases where no stamp duty has been paid. It paves the way for the unambiguous discharge of the duty under 33 and 35 of the Stamp Act. There may be, however, cases where it may be stamped, but the objection is taken by the party that it is not duly stamped. In such cases, no doubt it is ordinarily the duty of the court to examine the matter with reference to the duty under section 33(2). If the claim that is insufficiently stamped appears to the court to be on the face of it wholly without foundation, it may make reference on the basis of existence of an arbitration agreement. Otherwise, and then leave it open to the arbitrator to exercise the power under section 33 should it become necessary. This approach does justice to the word examine in 33(2) of the Stamp Act, while not ignoring the command of section 11(6)(a) of the Act. It is not to be confused with the duty to examine prima facie whether an arbitration agreement exists under section 11(6)(a), but is related to the duty to examine the matter under section 33(2) of the Stamp Act. Now, this particular passage says the court has two duties. 11(6)(a) is existence, 33(2) is stamp. And my power under 11(6)(a) does not take away my duty under 33(2). And my humble submission is that is in the teeth of section 5 of the Arbitration Act. Now, please see 33(2) and please see section 5. Kindly come to 33(2) of the Stamp Act, volume 4A. The Stamp Act starts at page 324 and 33 is at page 357. And if I may read that. Yes. Please come to page 357, volume 4A. Lordship has got 33(1). May I read now 33(1) and 33(2). Then I'll come to section 5 of the arbitration. Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office, except an officer of police, before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his function, shall, if it appears to him that such instrument is not duly stamped, impound the same. Therefore, my lord, the jurisdiction is conferred upon authorities who can receive evidence and office people who are holding public office. He shall impound the same. Now 33(2) is important. For that purpose, every such person shall examine every instrument so chargeable and so produce or coming before him in order to ascertain whether it is stamped with a stamp duty of the value and description required by the law in force in India when such instrument was executed or first executed. Now 33(2) is a very wide duty. You have to examine what? Examine whether it is of the proper value, valuation, description, which is classification. Is it a license? Is it a lease? Is it a bottom-up bond? Lord, we had a lot of controversy, mortgage, whether it's a mortgage, a conditional mortgage, different types of mortgage. What is the stamp duty? Lease license is a common problem. So you have to examine whether it's a value and the description required by a law when such instrument was executed or so and so. And not provided, all these things are there, which says that nothing contained shall deem to require a magistrate to examine or impound if it does not so think fit an instrument. But on the limited point of 33(2), I'm submitting that the word 33 includes the verb examine. The impounding under 33(1) has to be done after examination under 33(2). So 33(2) comes first. You prima facie see there's a document, it's not stamped. Then you exercise powers under 33(2). And then you. Now, please come to section 5 of the, yes, of the Arbitration Act, which 1207 in volume 4A. And in that context, my lord, I would rather your lordship sees the minority judgment of Justice Roy, where his lordship extracts section 5 of the UNCITRAL model, section 5 of the act, so everything will come in one place. Please come to para 341 of the NNG2 decision. Para 341.
Page number?
Page, I'll just page, just one second. Get that electronic page. 455, yes, 455. Of volume 5A. I'll start at 341.
455.
Lordship has got, 341, 342. Have all your lordships got 341 of minority view of Justice Roy? Very important. Further, on reading Article 5 of the Model Law and Section 5 of the Arbitration Act 1996, which cover the provisions for judicial intervention in arbitral proceedings, it is clear that Parliament went beyond Article 5 of the UNCITRAL Model Law and added a non-obstante clause. To substantiate this point, it is pertinent to quote the provisions in full. Article 5 of the UNCITRAL Model Law reads as under: extent of court intervention. In matters governed by this law, no court shall intervene except when so provided in this law. Now please come to 5, extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part, which is part 1.
So the of a non-obstante clause covering statute law in 11.6a
Yes.
is really dealt with by this omnibus non-obstante clause in section 5.
No, I'm grateful. I'm just putting for your lordship's kind consideration a further point. Now, my lord, 33(2) was already there when the Arbitration Act 96 came in.
Right.
There is an examination on the correctness of stamp duty. There is no doubt that your lordship exercising powers under 11.6a is an authority which can receive evidence. My humble submission is 5 must be read with section 11.6a, and when so read, it will prevail over 33(2) because these judicial intervention powers of the Supreme Court and the High Court intervention will only be to the extent provided in part 1. Because it says so provided. And the word so provided means only existence of arbitration agreement. And the word examine is used in 11.6a, examine is used in 33(2). There are 2 types of examinations. And the Stamp Act examination is expressly excluded, is my humble submission. Lordship may kindly consider. Now, my lord, while your lordship is on this, lordship will now come to an interesting paragraph. Now I'm now going into the realm of
the majority deal with section 5?
Pardon me?
How does the majority deal with section 5
deal.
in NG2?
No, they just extracted,
But they don't.
The subject to correction only Justice Roy deals with the UNCITRAL model. Para 120.
Let's just see that.
Yes.
PDF page?
388.
Let's see that right away.
Yes, I'm grateful. Para 8. May I read not para 1? Sorry, I missed this. Section 5 no doubt provides for a non-obstante clause. It provides against judicial interference except as provided in the Act. The non-obstante clause purports to proclaim, so despite the presence of any law which may provide for interference otherwise, however, this does not mean that the operation of the Stamp Act, in particular 33 and 35, would not have any play we are of the clear view that the purport of 5 is not to take away the effect of 33 and 35 of the Stamp Act. And my lord, in my humble submission, where the majority erred is 33 and 35 is not given a go by. It will be taken up by the arbitral tribunal.
And the object was to really therefore constitute part 1 as a code in itself.
Yes, absolutely. And I'm going to come to further 35 and 36.
The limits, at least insofar as judicial intervention is concerned, the limits of intervention were intended to be exhaustively specified within the ambit of part 1.
Yes. Otherwise, what you're doing is you're actually with such a barrier is posed, we're putting a coach and 4 through that barrier. We're saying, no. I got 11.6a powers, but my power under 33.2 also continue. I'm saying both can't continue. And the idea is, it's not that revenue will be lost or things will go. This will come before the arbitral tribunal. And Lordship will further come to section 35 of the Stamp Act and 36. Suppose in the course of arbitration, I tender an agreement and the other side doesn't raise an objection to stamping.
Really, stamping has nothing to do with validity as such.
Sorry?
Stamping
Nothing to do validity.
It deals with admissibility.
It's taxability and
agreement,
enforceability.
An unstamped agreement is not invalid. It cannot be
enforced
in evidence. That's what, and therefore cannot be cited as an exhibit.
Lordship, it'll affect its enforceability.
That's a specific provision, right?
Yes.
In the Stamp Act.
Yes. And I will also point out.
So the issue is where will it be debated? Is
Yes.
it debated before
Which forum?
Is it debated before the arbitration? It's a forum issue.
Yes. So it's not that, if the court ignores it, it is going to escape. And I'm going to make one further submission. So my
35 is very clear. That 35 says it will not be admissible in evidence. That's all.
Yes. But you please see section 36 of the arbitration of the Stamp Act.
That's the reason when you're going repeatedly on validity, I didn't want to interrupt you because it's not really, Stamp Act has got nothing to do with validity.
Exactly. No, but what will happen is I'm going to come to that. When I come, there's a very good passage extracted by the majority from Mullah, but I'll come. Please come to 36. What's this 36?
36 of Stamp Act.
Of the Stamp Act. That will be page 358, I think. 36. 358. 360 top.
That is, once it is admitted in evidence, it is not, cannot be called.
Yes. So that's going to be because the majority says an agreement not stamped is non-est in law, which I'm going to come to later on contract. It's bereft of existence. That may not be a correct proposition. So, my lord, if an agreement, and that's what Jhaverchand says.
Curable on payment of penalty.
Yes. My lord, I was going to say one thing. I sign an agreement. I don't stamp it. Now I run the risk if I don't stamp it under section 17 stage at execution stage. Tomorrow, if I want to enforce it, I have to pay 10 times the duty. So I take the risk. I know many cases where the arbitration clause is contained on the back of a bill or it's contained in some letter. Number of contracts take place between multiple parties. I don't want to go every time to the stamp, get a non-judicial stamp, get 100 rupees, witness, etc. I don't need it. I got an agreement. I got a very agreement. And again, the difficulty of the majority judgment is, suppose you say that I was an arbitration clause, it's not denied. How do you stamp that? It's in a telecommunication, electronic record. Now the amendments have been made that electronic record is a document and so on. Sorry. Come last two.
The issue that we're told that now, on the basis of NNG2, all existing arbitrations and objections being raised, that well,
Yes.
how could this
I'm
be?
coming to that because it's honest in law, not existing.
36 is a clear answer that once the document is marked in evidence, then their instrument cannot be questioned on the ground of insufficient stamping.
Yes. That's why in Jhaverchand, the Supreme Court points out that the party has to be vigilant. If it does not take the objection at that stage and allow the document to be marked, not be normal P1, P7 or whatever it is, then once it's marked as an exhibit, you can't at the argument, because it says at any stage of the proceeding, you can't then say that, look, it's not stamped, you should not have acted upon it. So, my lord, so my humble submission is, to conclude my submissions, 33.2, examination qua stamping.
Just, can you just formulate it?
Yes. My humble submission is, the majority judgment on this duty of the court to impound the document is incorrect because the majority did not notice Section 5, did not consider Section 5 of the Arbitration Conciliation Act.
Say we did not apply Section 5.
Apply Section 5.
Because they noticed it.
Correct. They noticed. I'm sorry, my apologies. Did not apply Section 5. In fact, they say Section 5 doesn't overtake my duty under 33.2. So my submission is, because of Section 5 read with Section 11A, the judicial intervention, so it contemplates that the court notices there is a flaw, there is a defect. But the court says don't intervene because it now must go to the arbitral tribunal where all these issues will be dealt with. So once judicial intervention is confined to existence of an arbitration agreement, the jurisdiction to examine stamping under 33.2 is taken away when court exercise powers under 11.6a. That's all. And with that, I'll come to Contract Act. Now, my lord, the more than Stamp Act, the difficulty in the NNG judgment is to say that if an agreement is not stamped, it is bereft of existence, it is void, and the majority says voidness and enforceability are conflated out together, which I'm humbly submit is may not be a correct interpretation of the Contract Act, because Lordship kindly sees they take 2G and 2H of the Contract Act. I'll come to the definitions. And then they say that if an agreement is not stamped, it is void. In my humble submission, if an agreement is not stamped, it is not void. It's a curable defect because you say an agreement. So I'll have to see 2G, 2H, Section 10 and Section 23 of the Contract Act. Yes. And Rod, while on and 28 also. They say it's non-enforceable. Permission. I'll read the statutory provision and then I'll try to submit that the judgment may not be in consonance with what is the statutory provision on contract law. Now, what they basically say is if an agreement is not stamped, it is not a contract. It's not an enforceable contract. And I'll show to your lordship that it's not, in my humble submission, not the correct view.
But that's
because
directly contrary to the statute itself.
That's my submission.
Statute merely makes it inadmissible in evidence.
That's all. That's all. And what it
It's a
says,
statute for the collection of revenue. So the cloud on the document, on its admissibility, not on the document or the transaction, the cloud on its admissibility is lifted by the payment of revenue and the penalty for not having paid it in the first place.
Lord, our concern is apart, as the lordship put it, apart from at various stages, this point is being raised and everything has come to a standstill. Sorry, my lord. Yes.
Should you not fortify your last argument of agreement being void, relying on Hindustan Steel, para 6 and 7?
Yes, yes.
Just kindly read it.
Hindustan Steel, Dilip Construction.
Correct.
Yes.
Kindly read two paragraphs, 6 and 7 respectively.
Of Hindustan Steel.
That's at page 588. What has just fallen from my Lord, the Chief Justice. Apropos what you argued the last.
Yes, yes.
Before you take over Contract Act,
Yeah,
the last part.
I am grateful.
Jamshid,
Yes.
para 5, volume 5 page.
Yes. At page 588. my lord.
588. It's a 3-judge bench decision.
Hindustan Steel is actually 1969, 1 SEC
Correct,
597
Correct.
at 600.
Correct. And it's a part of your paper book.
Yes, it is. It is. Yes. May I read, my lord? Para 6 and 7. I'll read para 5, my lord.
Yes.
May I read, my lord? Page 588, volume 5. An instrument which is not duly stamped cannot be received in evidence by any person who has authority to receive evidence, and it cannot be acted upon by that person or by any public officer. Section 35 provides that the admissibility of an instrument once admitted in evidence shall not, except in section 61, be called in question at any stage of the same or proceeding on the ground that the instrument has not been duly stamped. Relying on the difference in the phraseology between 35 and 36, it was urged that an instrument which is not duly stamped may be admitted in evidence on payment of duty and penalty, but it cannot be acted upon because 35 operates as a bar to the admission in evidence of the instrument not duly stamped, as well as to be acted upon. And the legislature, by section 36, in the conditions set out therein, removed the bar only against admission in evidence of the instrument. The argument ignores the true import of 36. By that section, an instrument once admitted in evidence shall not be called in question at any stage of the same suit or proceeding on the ground that it has not been duly stamped. Section 36 does not provide a challenge, does not prohibit a challenge against an instrument that it shall not be acted upon because it is not duly stamped. But on that account, there is no bar against an instrument not being duly stamped being acted upon after payment of stamp duty and penalty according to the procedure prescribed by the Act. The doubt is, if any, is removed by the terms of 42, which enact in terms unmistakable that every instrument endorsed by the collector under 42(1) shall be admissible in evidence and may be acted upon if it is duly stamped. 7, I'll read, Manoj. The Stamp Act is a fiscal measure.
It's more important.
Yeah, yes, ma'am. To enact, to secure revenue for the state on certain issues, on certain classes of instruments. It is not enacted to arm a litigant with a weapon of technicality to meet the case of his opponent. The stringent provisions of the Act are conceived in the interests of the revenue. Once that object is secured according to law, the party staking his claim on the instrument will not be defeated on the ground of the initial defect in the instrument. Viewed in that light, the scheme is clear. Section 35 of the Stamp Act operates as a bar to an unstamped instrument being admitted in evidence or being acted upon. Section 40 provides the procedure for the instruments being impounded. 42(1) provides for certifying that an instrument is duly stamped, and 42(2) enacts the consequences resulting from such. Then Lord, they go.
Allahabad High Court to the contrary.
Yes.
As an aside, Justice M.C. Desai, whose judgment is overruled, was one of those last few ICS judges in the Indian judiciary. But Justice Manoj Mishra will confirm, I think he was an ICS judge in those days.
And I think Allahabad had a English judge, Justice Broom, who was there well after independence. He continued till almost 73, 74. Falshaw was in Punjab. Most of the English judges left, but continued. Yes. Now, my lord, my submission is this. Yes. And Lordship will take page 369 of a majority. They doubt. To answer Justice Pardiwala's question, NN Global majority doubts Hindustan Steel at para 69. Lordship will come to page 368. 368, volume 5. Volume 5A, page 368. Para 69 at page 368 of volume 5, my lord. 5A. Yes, my lord, in the light of what Justice Pardiwala asked Hindustan Steel, there is a slight doubt expressed on Hindustan Steel in the majority judgment of NNG2, which is at page 368, para 69. So they don't expressly say it's bad law. Para 69, at the bottom of volume 5A, page 368. May I read?
Here also the power of impounding
Yes.
is only when it is produced before an authority.
Correct.
It's not, if you keep it with yourself, there is no impounding.
But
There's neither any proceedings under 31, 33, etc., don't apply. 33, etc. will
I'll
not.
just give an example. When I was a junior and I had a lot of work in the city civil court, and there was a particular well-known company which had a number of agreements with agents, 400, 500 agents. And out of 400, 500, 10 or 15 will default. And they were very, very keen on litigation. They would not spare anybody. So they would file suits. And only in those recalcitrant agents, they'll pay 10% the stamp duty. And the proprietor told me, why should I spend money on every agreement? Everybody is not going to default. Whenever a party defaults, that alone I'll pay 10 times the stamp duty. And it's a commercial call. Why not? Because 99 agents will comply with the law. The one person who don't comply is stamped. I'm also thinking to myself, what about electronic contracts? Now they are also taken as document. You simply say, I agree, click, crack, shrimp. There's a dispute. I suppose, I don't know how it's going to test it. In those cases where there's a dispute, you take a printout, stamp it. And what the what the majority finds fault is that they've not taken note of section 17, which is the taxable event. But Lordship knows in tax, there is always a difference between taxable event and the actual payment. Here what they say is, you take a risk. You either pay the stamp duty at the section 17 stage. If you miss the bus, or if you take a calculated risk of not paying at the section 17 stage, then when you come to 35, 42, etc., you'll pay 10 times the amount with the penalty. And there's also penalty under 62, which says that whatever extra you pay will be adjusted against the penalty. So my only submission is, as my lord slightly pointed out, this will not make the instrument, it's not fatal to the instrument. The arbitration agreement exists, the contract exists, it only remains unenforceable. So, my lord, these passages may require to be overruled, is my humble submission. Shall I take the section first and then the passage, or the passage first and then the section?
Section first.
Section first. I'm the Please come to the Contract Act.
The contract have been.
Yes, Lord, and one more thing I'll mention. One other argument I'm going to take, but Mr. Sakhardan elaborated. My view, my humble view is that arbitration agreement, because Stamp Act uses the word, Article 5 says agreement. Can it include an arbitration agreement? There's a serious doubt because there's a residuary clause, agreements not elsewhere specified. But all these require instruments. Now, one argument which he'll develop is that arbitration agreement need not be stamped in terms of the Stamp Act. That he will elaborate further.
We didn't need to go into that here at all.
No, I just leave it to Lordship, yeah. No, because NN Global holds. But in para 90, sorry.
Yeah?
In para 90, no, just to answer Lordship question, which Mr. Sakhardan will deal with. In para 90, they formulate the question and say, is an arbitration agreement liable to be stamped? And in fact, in my curative also, what's happened is it's an agreement to lease. If an arbitration agreement is contained in the larger contract, suppose the main contract stamping is 1,000, but it's only an agreement to sell, not a sale per se, and there's an arbitration agreement. Suppose I put it as 100 rupees. Some cases they have put arbitration agreement stamp. Here, agreement is mentioned in Article 5, and the last says, like a residuary clause, agreements not elsewhere specified. But the nature of 7.1, 7.2, 7.3 shows that arbitration agreement has not been included in the, for example, in the case of award, Supreme Court has said award doesn't include a foreign award for Stamp Act purposes. So maybe agreement that Lordship, he will consider, Lordship may decide whether to take it up or not later. So I'll straight away come to the Contract Act. Now, my lord, what is the role of the contract?
We are really on the narrow issue as to
1160.
what is the stage at which a dispute about stamping has to be decided. Does it arise at the stage of 11.6?
Yes.
Whether an arbitration agreement should or should not be stamped ultimately, and we don't have the states here before us. So
yes, and my humble submission is, the Contract Act, in para 152, the majority makes a division. If it is absolutely without foundation, they can step in. If it is partly without foundation, it has to be left to the arbitrator. But on my humble submission, that creates a lot of uncertainty in the law.
that's where they say if it is not absolutely unstamped,
Yes,
insufficiently stamped, then send it to the arbitrator.
send it to the arbitrators.
If you find that there is no foundation, no foundation, the objection to stamp.
My humble submission is,
that distinction.
yeah, that's the distinction. I'm saying that should not be made because
This is accepted.
majority says 152.
There's a curable
Lord, as Mr. Mehta rightly points out, please come to page para 166. Para 152, they say sufficiently stamped, insufficient, but para 166 and 167 are clear.
Which
If it is
page?
not, page 399. These are the two observations which Lordship will see 166, 167. All your Lordships have got it
At page?
at page 399, volume 5A. Yes. An arbitration agreement within the meaning of section 7 of the Act, which attracts stamp duty and which is not stamped or insufficiently stamped, cannot be acted upon. In view of section 35 of the Stamp Act, unless following impounding and payment of the requisite duty, necessary certificate is provided under section 42 of the Act. So, my lord, they say at 11.6a you stop.
Where do they
impounded-
deal with section 36?
Next, they don't deal with section 36. Please, subject correction. They note it, yes.
They don't deal with it.
Yes, I'm coming to that, exactly coming to 36, next paragraph. We further hold that the provisions of 33 and the bar under 35 applicable to instruments chargeable to stamp duty under section 3 read with schedule would render the arbitration agreement contained in such instrument as being non-existent law unless the instrument is validated under the Stamp Act.
Now therefore,
This is completely in the teeth of 36. If the agreement is non-existent in law, it can't even be, 36, what it says is, if you don't take the objection to stamping, you can't question it later. You can't say it's not existing in law, sorry. Yes. And to your answer also, para 108, they discuss section.
381 lot, page 381, volume 5A, paragraph 108, going over the page of 382. Three 381 lot, 108 paragraph.
But it spills over to 182, yeah.
It's over the
Equally, placetum A. What have you seen that one? So, my humble submission is both para 166 and 167, in my humble submission, do not represent the correct position of law. And the correct proposition should be that if the agreement, first of all, under 11.6a, you do not need to look into the Stamp Act at
Last
all.
sentence of paragraph 108,
Yes,
just read that.
it is not invalid or void.
What, start from one sentence above that.
Sorry.
Thus an unstamped or insufficient text.
Yes, yes. Placetum B. Now, I'll just read further, equally under section 36. That's better. My Lord Justice Khanna asked me to has drawn the attention, para 108 at page 381. All your lordships may kindly come to page 382, placetum A, my lord. Equally, may read not equally, the third line, under section 36, in the case of an instrument, not secondary evidence of the instrument, which is allowed to be let in evidence without objection, then it would qualify as evidence founding a right. But this is an exception to the rule found in section 35 of the Stamp Act. Thus, an unstamped or insufficiently stamped instrument representing a case of an agreement which is not being enforceable, in the sense that the sanctions in law through a civil action is impermissible. In the said sense, invalid. It is not invalid or void in the sense of it being stillborn or null and void, or in the sense that life cannot be poured into it. Now, while they say this, I'll show other paragraph where they say, once an agreement is not stamped, it is completely void, it is bereft in law. Now, since your lordship is seeing that, my lord, I'll just, with the court's permission, go to the other paragraphs. Please come to para 103. I'll just take a lordship through 103 and then 109. Lordship will just come to 103, my lord, on stamping. No, 102, I'm coming last. Mullah, no? Yeah. I read 103, my lord, at page 380. I read, no? We would find that an agreement which is unenforceable on account of a substantive law, which would include the Stamp Act, would not be a contract. Section applying section 2H of the Contract Act, it is only if the agreement is enforceable that it would become a contract. It is only a contract which would be the arbitration agreement which is contemplated in section 11(6)(a) of the Act. It may not be apposite to merely describe an unstamped arbitration agreement as a curable defect. As long as it remains an unstamped instrument, it cannot be taken notice of for any purpose as contemplated in section 35 of the Stamp Act. It remains unenforceable. Section 17 declares the time at which instrument is executed in India must be stamped. The said provision contemplates that stamping of such an instrument must take place before or at the time of execution of the document. No public officer, nor court, nor arbitrator can permit any person to ask them to act upon it or receive it as evidence. In law, it is bereft of life. It is not unenforceable in law. It is not enforceable in law. In the said sense, it also cannot exist in law. It would be void. Our view in this regard is that voidness is conflated with unenforceability receives fortification from 2J of the Contract Act, which renders a contract which ceases to be enforceable void. What section 11(6)(a) contemplates is a contract and is not an agreement which can be treated as a contract. Number one, they go further. When they use the word arbitration agreement, the court says it is a contract. This is despite the use of the word arbitration agreement in 11(6)(a). In other words, contract must conform to section 7 of the Act. It must also, needless to say, fulfill the requirements of Contract Act. Then Lordship will come to 109. 382. We may sum up. An agreement which is unstamped or insufficiently stamped is not enforceable as long as it remains in the said condition. Such an instrument would be void as being not enforceable. See 2G. It would not in the said sense exist in law. It can be validated by only the process contemplated in section 33 and other provisions of Stamp Act. We find the expression validation used in the decision of the court in Hariom Agarwal, which we shall refer to in greater detail later. This necessarily means that the court would not view it as unenforceable, as enforceable, and therefore existing in law. In the sense explained, it would not be found as not void and therefore not invalid. Thus, in the context of the Act, the Stamp Act and the Contract Act, we have the view that the opinion of the court in SMS estates regarded in Garware and so is correct. Then para 110 is important. 11(6)(a).
In fact, few days before the judgment was pronounced in this case.
Your Lordship has clarified that.
It doesn't deal with that issue.
Career Institute.
I don't remember the name.
Career Institute. Yes. But actually, Lordship never went into the Stamp Act. The opening question itself is very clear, my Lord. Now, my Lord, please see para 110. 11(6)(a) cannot be understood as merely predicating for an arbitration agreement existing literally. This means that the mere existence of an arbitration agreement for all intents and purposes on the exterior, purporting to project a contract duly executed, may in certain situations be insufficient under section 11. If for the reasons such as it being unstamped, when it is clearly required to be stamped, then it cannot be said to be a case where the arbitration exists, or it would be no existence in law. While we agree, the court must be careful in selecting contracts where an arbitration agreement which is produced is not to be acted upon, for the reason it does not exist in law. All we hold is that an arbitration agreement which is not unstamped does not exist, and an unstamped contract containing an arbitration agreement would not exist as it has no existence in law. Now that is contrary to the Stamp Act and also contrary to the Contract Act. And I'll take your Lordship now to the provisions. But before that, since your Lordship is having this thing, the page, please see the excellent passage of Mullah at page 102. Para 102 at page 380. Para 102. Pertinently, my Lord, may I see? May I read? Para 102 at page 380. Pertinently, we may, in the 14th edition of the Indian Contract Act and Specific Relief Act by Pollock and Mullah, note as follows: unenforceable contracts. unenforceable contracts are valid in all respects. Very important. Unenforceable contracts are valid in all respects, but may not be sued upon by the parties. Enforceability is linked. When do you say a contract has to be enforced? When one party does not perform as part of its obligation, you have to get it enforced. Who will be the agency to enforce? Under our system, the judiciary's job is to enforce it. It says that, but may not be sued upon. So if a contract or an agreement is not stamped, it cannot be sued upon, that's all. But it is valid in all respects. Please see further, Madam. Such disability may arise for want of registration, or because the time prescribed for filing the suit has expired, or because the plaintiff firm has not been registered, that's section 69, or the document or instrument does not bear the requisite stamp duty, or because the lender of money does not possess a license under money lending laws. Now, Lordship will kindly see what has been held by the learned authors is the correct position. And in my humble submission, what is said in para 103 and 109 is contrary to these position of contract law. And now let us go to the sections and I'll conclude. Lord, we have to get the legal concepts of what is void, what is unenforceable, very clear, my Lord. And that's why from law college, we've taught that you cannot use the word void contract. It's an oxymoron. A contract may become void because of supervening circumstances. It's only a void agreement. And please come to section 2G, 2H, section 10 and section 23.
2G.
What you will come to the definition of Contract Act. 281, one second. Contract Act is 281, volume 4A. May I read, Lord?
Yes.
Your Lordship must first come to 2E. Every promise and every set of promises forming the consideration for each other is an agreement. Then come to 2F. Promises which form the consideration or part of each other, reciprocal promises. Now 2G and 2H are critical. An agreement not enforceable by law is said to be void. An agreement enforceable by law is a contract. Now, Lordship has to see 2H and go straight away to section 10 and 23. Those agreements which don't satisfy section 10 and section 23 come under 2G, which are not enforceable by law. I'll repeat, my lord. 2H must be read with 10 and 23.
And those agreements, you said?
Those agreements which don't satisfy the parameters of 10 and 23 will be agreements not enforceable by law and which are void. Now please come to section 10. This is the origin of the phrase that all contracts are agreements, but all agreements are not contracts. Now please see section 10. What agreements are contracts? See the marginal note. What agreements are contracts? All agreements are contracts if they are made by free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India and not hereby expressly repealed by which any contract is required to be made in writing or in the presence of witnesses or any law relating. Lordship will just note in margin, this nothing is refers to section 25 of the Contract Act. promise to pay a time-barred debt, agreement, I'll come to 25 minutes. I'll just finish the sequence. Now, please come to section 10. Section 10 basically says free consent. And when is consent not free? Then your lordship goes to 15, 16, 17, 18 of the Contract Act. 15 is coercion, 16 is undue influence, 17 is fraud, 18 is misrepresentation. If consent is vitiated by these four factors, it becomes voidable at the option of the aggrieved party. So consent is free. Parties competent to contract, majority, there must be a majority age. Then if it's a company, it cannot be ultra vires, the objects clause. For a lawful consideration, lawful object, that takes us to section 23. And I just mentioned not expressly declared to be void.
Not hereby expressed.
Expressly hereby declared.
Hereby means in this act.
In this act, yes. Now, lordship will kindly come to section 23, which is at page 286. May I read, my lord? 23. What consideration? The consideration or object of an agreement is lawful unless it is forbidden by law, is of such a nature if permitted would defeat the provisions of any law, is fraudulent, involves or implies injury to any person, property of another, or the court regards as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. And my humble submission, stamp is never the object or consideration of an agreement. Stamp is an incidental part. But object is what we call parties are ad idem. Consideration is in 2D of the Contract Act. When at the desire of a promisor, the promisee, etc., that follows. So my humble submission is, now taking the Contract Act with the Stamp Act, reading 2G with 10 and 23, even if an instrument is not stamped, it is not void under the provisions of the Contract Act, but it becomes unenforceable in view of the Stamp Act. Yes, as my friend points out, it is not even avoidable. Now, lordship will kindly come to 24 just to complete what they say. If any part of a single consideration for one or more objects or any one part of several considerations, single object unlawful, the agreement is void. So you can't apply severability there. It's like the one drop of poison which spoils the milk. Now come to section 28. At page 288. Explanation, exception 1. Ali 28A. Every agreement by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his right, or which extinguishes the rights of any party thereto, or discharges any party from enforcing liability under or in respect of any contract on the expiry of a specified period so as to restrict any party from enforcing his right, is void to that extent. So basically, my lord, if you say you shall not approach the court, or you can't approach the court after a particular period, then that is void. Exception 1 is important. And 2, this section shall not render illegal a contract by which 2 or more persons agree that any dispute which may arise between them in respect of any subject or class of subjects shall be referred to arbitration, and that only the amount awarded in such arbitration shall be recoverable in respect of the dispute so referred. Exception 2, nor shall this section render illegal any contract in writing by which 2 or more persons agree to refer to arbitration any question between them which has already arisen, or affect any provision of any law in force for the time being as references to arbitration. Now, Lordship will kindly note, very, very important, the agreement between two parties that they shall refer the dispute is a contract. 28 does not require that that contract should be stamped. It can be oral.
Yes.
Now come to 2G, an agreement not enforceable by law is said to be void.
So stamping really is not part of
This
this.
is not part of my humble submission. And most important, section 23, because the court says if you don't stamp it, it's non-existing in law. No. And I'm submitting that the existence of an agreement has nothing to do with voidness. An agreement may exist. All that happens is it's unenforceable. For what the majority in my humble submission heard is, they say that which is not stamped is void and unenforceable. They say that both voidness and enforceability are synonymous. What para 108 says, Your Lordship kindly comes. Para 103. Our view in this regard that voidness is conflated with unenforceability receives fortification at page 103 in italics. 380. That's very important. But because this goes far beyond the realm of stamp law. A bench of 5 judges, when it holds this, it affects every other agreement, even beyond the Stamp Act. They'll say, look, this is Article 141. If you don't stamp it, it is void. And it may not be, I may not be only bothered about the arbitration. I cannot enforce it in a proper civil court also. We are concerned with arbitration. What they say is my agreement is not stamped, it is void. And one more thing, my lord, there is an inherent contradiction. There is no question of resurrection. What they say, if it is void, then where is the question of it springing back to life after stamp duty is paid?
Then it's still born.
It's still born. It's gone. It's not like the doctrine of eclipse.
I was just going to say, Ambika is just KK
Because,
Matthews.
yes, Bikaji Narayan Doctress, that once the eclipse is removed, it assumes force proprio vigore. All that is not there. There's no resurrection. So, my lord, the proper test of the law will be this. But I'll summarize my proposition to say that the Contract Act, the validity of a contract is independent of the requirement of any stamping. As Mullah says, even an unstamped contract is valid in all respects, but you can't sue upon it. Then, Lord, the last point I'd like to make is that on this question of original and certified copy, para 137, 141.3 and 144.
Page number?
Page number is page 130, para 132 is 388.
37 is page 388.
Yes. 391.
Yes.
It starts at 132. Lord, the heading is interesting at page 87. Amicus brings a surprise. That is Mr. Banerjee.
Para 137. 131.
I don't know what he's going to do in this bench, my lord.
A sudden googly bolt by Mr. Banerjee.
Yes. Now, my lord, my humble submission is at page 131, para 131, at page 388. I'll read, Lord. This court pointed out the existence of the scheme prepared by the Supreme Court in exercise of powers under 111.10, para 2A of the scheme inter alia reads as follows. Submission of request. The request of the Chief Justice under subsection 4 or subsection 5 or subsection 6 shall be made in writing and shall be accompanied by the original arbitration agreement or a duly certified copy thereof. Thereafter, when the curtains were about to be rung down by the hearing, the learned amicus brought the following aspect to the notice of the court. He pointed out that under the scheme, the applicant need produce only the certified copy of the arbitration agreement. He would draw support from the judgments of Jupudi Keshav Rao versus Pulavarti Venkata Subbarao and Hariom Agarwal to contend that even applying section 33 and 35 by the court at the stage of section 11, the certified copy cannot be impounded. He thus sought to take the wind out of the sail of the appellant's contention by contending that in most of the cases, since certified copies alone are being filed and they cannot be impounded, and as reference to the arbitrator based on certified copy, the arbitrator is competent under section 33 and 35 to do the needful. This court may bear this aspect in mind. Thereupon, Shri Gagan Sanghi would point out that even in the certified copy, the factum of payment must be entered. This set expected. My humble submission is, please come to para 137. Yes. 391. I'll read 137 and 141.3. The submission appears to be that the scheme provides for a certified copy of the arbitration agreement if the arbitration agreement is part of the contract, which is either not stamped or insufficiently stamped. And since it cannot be impounded under section 33, cannot be validated, all that a court has to look into is whether the arbitration agreement exists. What it meant is whether the arbitration agreement duly stamped exists, what that ultimately mean, though they don't say so in some videos. Then 141 is the interplay of evidence, para 141, Interplay of Evidence Act, Stamp Act, Registration Act, and then they conclude this. But my submission is this, as far as certified copy is concerned, this Supreme Court scheme is pre-2015. After 2015, when I make an application under section 11(6)(a), that is, rules can't be contrary to the act, my humble submission is the registry will be bound to receive the application because the court's jurisdiction is only to see the existence of the arbitration agreement. So there's no, and suppose it's exchange of letters. Suppose it, of course, letter also the proviso says any one letter can be stamped. But suppose it is electronic, telecommunications. What do you do? So that
after 2015, you said when the application under section 11(6)(a)
is filed,
the registry,
there's no need to produce the original or certified copy.
yes,
I can just file a copy, any copy. It need not be certified.
So
It can be a true copy.
Mr. Dattat, what you're propounding then is that only amendments in the petition should be made.
With a copy of the agreement if it is there. Or suppose, if its agreement is there. Sorry.
The reason why they don't ask for the original is because it may be with the other side.
With the bank or something else.
Obviously, it's to certified copy has always been, whether it's High Court, it's been always, that does not say certified copy or anything like that. So it leaves it as a matter of procedure. So this is the reason why the rules, several high courts also, the rules provide, you have to give the certified copy.
Many high courts don't provide that also.
They
Delhi
may
High
not-
Court, not in fact.
No, we have been insisting in Delhi High Court also, that when we were there, that the certified copy should be there. Sometimes it's there in the parent contract, like in general conditions of contract, there is
Yes.
a provision.
Yes. But my learned friend did some research. Delhi, Karnataka, Orissa, MP, Gujarat don't require either original or certified copy. But now my submission 11(6) says the jurisdiction is so limited. I can tender my agreement and say this is a copy of the agreement. It need not be certified. It need not be original.
No, the issue, probably what I could make out from the
Yes.
judgment is, they've said certified copy refers to public documents.
Yes.
Certified copies of public documents.
No, what they say certified copy or true copy is the Xerox copy must show that stamp has been paid. What was argued was the Xerox copy will
Show
show
that.
stamping.
But then they have not overruled Hari Om Agrawal and
No. They're not. My only submission is 11.6a must be given a full play. And now there is no need to get into original certified copy and so on.
because overruling that would have meant the whole case law which has been
Yes,
built up over
quite,
the
yes.
years.
That would have again not necessary also. So, my lord. Yes. So, my lord, I'll just conclude because section. Lord, I've
Let me rise. I mean, just apropos what both my learned CMO's colleagues said, we can title this proceeding as the interplay between the Indian Stamp Act and the Arbitration and Conciliation Act 1996.
or like, or in real section 11.6a of the arbitration act. Like
It may rise under section
the
8
arbitration
also.
act. Okay.
But 1160 will become very broad.
Very
We are
well.
considering the stamp.
Very well, very well.
तो आप ऐसा title कर दीजिए. Should we say whether Surikant, Jamshed and
Which means that section 9 would also be considered.
I was about to ask because I've dealt with 11.6a. I've finished, my lord. If your lordship wants me to just give briefly on the impact of stamped qua section 8 and section 9, I'll make my submission. Then I've finished, my lord.
Would your, then say the interplay between an arbitration agreement and the Stamp Act?
That's better.
Because for institutions, 1160 would not even arise.
My lord, it'll be interplay of arbitration
The
agreement, stamp
interplay
act and
between
contract.
Arbitration agreements
Stamp act.
under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act
1899 and the contract act also. Okay.
Contract Act is an argument, right?
Okay, very well. So, my lord, should I deal with section 8 and 9 for 5 minutes after lunch, or shall I leave it at the moment? Because we are doing 11.6a per se.
It's important because in the 20.
All right, then I will deal with it in 10 minutes.
We'll consider whether to expand the ambit.
Yes, but I'll just make my
We're
submission.
now almost wrapping up, so next
Finish, I
5
finished.
minutes and.
I finished.
And this side, we request today, end of the day is the deadline.
We discussed among ourselves at lunch. Initially, my brief was to confine to 11(6)(a). But to save time, I think Jayant Mehta and Nikhil will deal with section 8 and 9 and stamp act, so that they can argue.
Thank you very much.
Very grateful for a
Thank you,
patient
Mr.
hearing to all
Rao.
your lordship.
Thank you.
All the best.
And I'm going to make 3 or 4 submissions. The first of it is, and I'll straight away formulate it, without wasting much time because the lordship knows the background. The first of it, is that the arbitration agreement.
Just one second.
Sorry. Well, my first submission is that the arbitration agreement is not chargeable to stamp duty. Because the original question, which was referred to the 5 judges, if my lord just has a look at the original question that was referred to the 5 judges, and that is, at page 293 of volume 5A, which, I submit was the correct question. Page 293, volume 5A, which, I submit was the correct issue. Paragraph 58.
Eight.
58. We consider, may I read it?
Yeah.
We consider it appropriate to refer the following issue to the authoritative settled by a constitution bench of 5 judges. Whether the statutory bar contained in 35 of the Stamp Act, applicable to instruments chargeable to stamp duty under section 3 read with the schedule of the Act, would also render the arbitration agreement contained in any such instrument, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid, pending payment of stamp duty on the substantive contract instrument. This was not the original
Meant by
question.
these words, Mr. Sakadande, which is not chargeable to the payment of stamp duty, does that postulate that an arbitration agreement is not chargeable to stamp duty?
Yes, Milord, that would be my submission. And Milord, what happened before the 5 judges is
But did they
reformulate. I want to read
reformulated the question?
on the basis of a concession made. The reformulated question, if I may just pose for your lordship's consideration, is at page 352 of volume 5A. And I'll just, make 3 short propositions on why, it is not chargeable to stamp duty.
Please, please.
Page 352, volume 5A, is the reformulated question based on the concession by the amicus curiae, learned amicus curiae. Paragraph 32, Milord. May I read it? In view of the submission made by the learned amicus curiae, that the court in NN Global was in error in proceeding on the basis that the arbitration agreement would not be exigible to stamp duty, the very premise of the order of reference would stand removed. The reformulated question sums the words which is not chargeable to payment of stamp duty and words unenforceable or invalid would therefore be as follows. Whether the statutory bar contained in 35 of the Stamp Act applicable to instruments chargeable to stamp duty under 3, read with the schedule, would also render the arbitration agreement contained in such an instrument as being non-existent pending payment of stamp duty on the substantive.
It's a correct reformulation of the question.
But
For the reason that the words which is not chargeable to payment of stamp duty is a hypothesis. So if you begin with the hypothesis that it is not chargeable to this payment of stamp duty, then what are you deciding? So what they decided, they just deleted that part, which was a premise. The premise was which is not chargeable to stamp duty.
which, Milord, in my respectful submission, was the correct premise. It was the correct premise for this reason.
It can't be a premise. It's a question which has to be answered.
But so far as, Milord, today the question is.
It is reframed as a question of law.
Yes, sir.
And that is the question of law which is sought to be answered. We'll have to Proceed on the premise of that question of law.
But my lord, if the correctness of the judgment is now under review by a bench of a larger
You want us
bench.
to reformulate the question of law itself in the same sentence.
My lord, I don't want your lordships to reformulate, but if the basis of this judgment is that it is chargeable to stamp
No,
duty.
it is not. That's not the basis of the judgment. But the basis of the earlier question was that it is not chargeable to stamp duty.
Which is correct.
But that's an argument.
That's an argument.
Probably
That's an argument.
your only contention is the question of law was, as framed was, if the parent contract, underlying contract is not properly stamped, will it affect the arbitration clause contained in that contract? That may be your contention.
But, my lord, yes.
But they have answered it much bigger.
But my lord, so far as an arbitration agreement is concerned now, after applying the doctrine of separability, they have not separated the arbitration agreement and not said that under Article 5 residuary clause, it is now taxable under the residuary clause. Now, my submission for your lordship's consideration on chargeability is that when you're applying the doctrine of separability to a stamping statute.
Sakadende, how did the issue of chargeability arise at all? The question was the state in a proceeding under section 11(6)(a). Does the court go into the question of whether the agreement is stamped or otherwise? That was the issue. Whether arbitration agreements are per se subject to stamp duty or not really didn't arise, and it may depend upon the nature of the underlying contract.
But my lord, even then, even so, as a proposition of law.
Suppose the underlying contract is an agreement to sell immovable property.
That's it.
And together with it, just throwing an example,
With an arbitration.
possession is delivered. Now, I know that as a matter of fact, say in the Bombay Stamp Act, the Maharashtra Stamp Act, it's treated for stamp duty as if it were a sale agreement.
Yes.
So it would depend very much on what facts are before you in that case.
But then, my lord, I'm not saying that the main contract need not be stamped or should be stamped, or whether that can be gone into an 8.
But should we go into it here before 7?
It will not, that would be required for this reason, that if I'm in a position to convince your lordship that an arbitration agreement which is made chargeable to stamp duty is based on a legal fiction which doesn't apply because it's based on the doctrine of separability. The doctrine of separability, my lord, was evolved for the purposes of saving an arbitration agreement. If that fiction is something, my lord, which was created for that purpose, namely the arbitration
It
act,
will apply to the Stamp Act also.
it would not apply to the Stamp Act because it will not have an extended application. Now, if, my lord, that legal fiction for which this legal fiction was incorporated in section 16, namely the Arbitration Act, if that fiction, my lord, has to be restricted for the purpose for which it was created, the stretching of that fiction to something outside the purpose is not permissible.
So the consequence would be then that the arbitration agreement would be treated as an integral part of the original contract.
Correct. Now after
In your
that,
submission.
in my submission, correct. Now, my lord, if that is so let us, my lord, then say that it now, my lord, comes under one document with an arbitration agreement. Then, my lord, the provisions of section 5 of the Stamp Act would apply. For the purposes of stamping. For the purposes of stamping the agreement, the arbitration agreement, not the main contract. Now, when we
once you treat the arbitration agreement as not severable and an integral part of the main contract, then the entirety of the contract has to be stamped.
But, my lord, therefore, that so far as that part is concerned, the arbitration agreement would also have to be stamped, provided it is a distinct matter under section 5 of the Stamp Act, not of the arbitration, of the Stamp Act. Would your lordship just have a look at section 5?
Of the Stamp Act.
Why are you raising the point? Of the Constitution.
My lord, may I just show to your lordship first the Constitution bench, my lord, paragraph 88 to 90.
This is why you're arguing the point.
Which is why I'm. If your lordship sees paragraph 88 to 90, page 374, paragraph volume 5A. It will always be. Paragraph 89. A perusal, may I read?
Yes.
A perusal of paragraph 29 would show Well, 88 if your lordship does not. As far as the finding in paragraph 28 of NN Global, that the decision in SMS does not lay down the correct law, when it holds that an arbitration agreement in an unstamped commercial contract cannot be acted upon or is rendered unenforceable, we are of the view that the finding in NN Global does not appear to be correct. A perusal of para 29 would show that the court in NN Global proceeded on the basis that the arbitration agreement, being an independent contract, is not chargeable to payment of stamp duty, and it would not invalidate the arbitration clause or render it unenforceable, since it had an independent existence of its own, cannot hold good in view of the admitted position before us that an arbitration agreement in its own right is exigible to stamp duty. Now, in para 90, the whole premise of the court in NN Global being that the arbitration agreement not being exigible to duty and it having a separate existence, the commercial contract in which the arbitration agreement is contained, being unstamped, would not impact the arbitration agreement, cannot hold good. The reasoning in NN Global in para 32 for approving of Karwari in paragraph 22 thereof, that the arbitration clause would be non-existent in law and unenforceable till the stamp duty is adjudicated and paid on the substantive contract, is again on the premise that the arbitration agreement is a separate agreement under the Stamp Act, which is not exigible to stamp duty, which we have found is not the case in law. Now, my issue, my lord, is separate agreement under the Stamp Act is, my lord, something where the legal fiction, my lord, of separability, which is to be confined only for the purposes of the Arbitration Act, has been applied to the Stamp Act, and therefore, my lord, the arbitration agreement has been made stampable, which, my lord, in my respectful submission, is not permissible.
Yes.
Now, my lord, if your lordships now turn to the Stamp Act for a minute. So this is the first reason why, my lord, the arbitration agreement is not subject to Stamp Act. The second reason, my lord, would be if you're on the reading of section 5, my lord just has a look at section 5. I'm arguing this today before your lordship because the premise of the Constitution bench that the arbitration agreement is stampable is, in my respectful submission, erroneous. Now, if my lord turns to section 5, which is at page 338, volume 4A, and then, my lord, I'll come straight away to the decisions on this. I'm sorry.
Yes.
Any instrument comprising or relating to several distinct matters can be chargeable with aggregate amount of duties, with such separate instruments, each comprising or relating to one of such matters, would be chargeable under this Act. Now, in order to not fall within the expression distinct matters,
So you have to accumulate the stamp duty. That's what this.
you would have to accumulate the stamp duty, but provided it is a distinct matter. Now, in my respectful submission, first of all, my lord, an arbitration agreement would not be a distinct matter because the doctrine of separability does not apply to arbitration agreements when it comes to stamping. The legal fiction cannot be extended. The second reason is that an arbitration agreement being ancillary to the main agreement
Nishi, why do we have to get into this at all? Because, you know, the genesis of the dispute was whether in a 11.6a application, you can look at whether it has examined whether the documents been properly stamped or otherwise. Should the power of impounding be exercised by the judge in the 11.6a stage? Now, for us to go into whether an arbitration agreement is at all stampable, we are saying it can never be stamped. We don't have facts. We don't have, for a bench of 7 to decide this question would be very, very.
Very well, then I.
Very briefly respond, Manoj, why it may be necessary to decide not this aspect, but other aspects. We are concerned with 11.6a here, which is the appointment of arbitrators by a court. But there's a vast body of appointment that takes place by individuals outside of a court. Every matter doesn't come under Section 11. Secondly, increasingly there is institutional arbitration. Institutions have to appoint. Again, they are not courts under 11.6a. It is perhaps necessary, if your lordships, to clarify that position as well. Not on the lines my learned friend is arguing. I disagree with what he's arguing. But it is necessary to set out the principle that all these matters
have to be decided by the arbitrator. There we are with you, Mr. Kamata, that we have to decide that issue. That what we say in relation to a court for a 11.6a application, you say would apply when an institution is appointing an arbitrator.
Or an individual.
That's right. For instance, the Delhi International Arbitration Center, when you know, somebody moves the DIAC, you don't go into stamping. That will be decided according to you by the arbitrator.
Obviously, though, the judge bench has said that the Indian Stamp Act applies. I put it in my submission. I'm not going to labor it. Actually, the Indian Stamp Act does not apply. It's the state acts that will apply because they are residuary clauses. But that really doesn't arise before your lordship, but I put it in only for clarity. The Indian Stamp Act won't apply at all because under entry 91 of list 1, the remit of what Parliament can do to fix rates of stamp duty is very limited. In fact, the residuary power is with the states. So the Indian Stamp Act doesn't apply at all.
I think
I'll leave it at that.
I think I'll leave it at that.
Stamp litigation in the states is on their local stamp acts.
But I'll also leave it at that.
That's and they're normally on arbitration agreements as residuary arbitration.
Constitution de do.
100
Constitution de do.
Under the Indian Stamp Act, it is 4 annas.
The main contract. That's a different issue. That
But-
was fairly false before the crisis. But yeah.
The levy can have their preferences as a courts officer. Although not might be exempted in A state, but maybe subject to standard.
That's right.
The minority will not be able to find that when you also come to a conclusion that it may be subject to standard and find that NN one, NN global one was wrong on that.
The interpretation of
Minority group.
look at
It's just a courts officer.
To as an agreement, if there is separate enactment, separate entry, it will be subject to that,
Whatever the state act provides.
whatever the state act will provide.
And most have, or many have residuary clauses.
Maybe the reserve, because it may be applying to the agreement.
So you are right. Sorry, go ahead, you're saying something. As Mr. Kambata said, entry 91 of the union list, which is what the Indian Stamp Act is referable to, says, in this book, page 472, rates of stamp duty in respect of bills of exchange, checks, promissory notes, bills of lading, letters of credit, policies of insurance, transfer of shares, debentures, proxies and receipts. That's the only remit of the Indian Stamp Act. Now see entry 63 of list 2.
Correct.
Page 476. Rates of stamp duty in respect of documents other than those specified in the provisions of list 1.
So the residuary powers with the states, and your lordships have held so. In the Rama Sharma case, I've cited that in my submission. I'll just briefly place that for your lordships.
Because I think what we'll do is, I think I'll leave it at that. I won't labor this point anymore.
No, but what do we do about the finding of the majority then?
That's the reason.
On this, yes.
Both say that it's chargeable to
Both
stamp.
states also say it may be charged because
No, Any global one, like that, Article 5, not of the stamp, of the schedule. Of the schedule to the stamp act.
No, section 5 may not apply. Section 5, when there is a mother contract, because section 5 applies if they are separate transactions in one document.
In one document.
It doesn't apply otherwise.
We,
It doesn't apply mainly because subject matter is connected with some.
Let me address my thoughts briefly on that.
no,
No, leave it at that. We'll examine it in.
I was suggesting, my lord, to leave it to the facts of each case.
That will be decided.
On whether,
Paragraphs from the minority, where the minority also says this, it's 291, 292, 295 of Justice Rastogi's opinion. And 312, 412, 415
Minority?
is, minority comprises of two independent opinions.
Yes.
Of Justice Rastogi and of Justice Roy. But Justice Rastogi's opinion is to be found in paragraphs 292 and 295, which would be PDF 436 of volume 5A. And Justice Roy's opinion, Roshas may kindly note not paragraphs 312, 412 and 415. 312 is at 442, 412 is at 478 and 415 is at 479.
And 312 is at page?
312, my lord, is at 442, where they say that it's actually the court in NN Global 1 lost sight of Article 5 to the schedule of to the stamp. Article 5 to of the schedule to the Stamp Act.
What does that say?
That contains a residuary entry saying that any other agreement not provided for will be subject to the Stamp.
Yes.
that is the residuary article under which it is made sample.
So it may be taxable. It may be.
I was suggesting.
The presumption in the question as framed that it is not stampable is not correct.
That was
If
the
not
opinion
otherwise
said.
provided
No,
for.
it was- it
If
was-
not otherwise provided
That's
for.
it, that's it.
And it says 8 annals.
The majority in 5-judge bench goes by consideration of Article 5. Minority also takes Article 5 into consideration to say NN Global 1 was wrongly decided on that account, but holds otherwise on the mechanism.
Mechanism.
So, my lord, I was
It
suggesting.
may be, in some cases, it may not be taxable.
That's correct.
Where it's not
Like
executed.
section 3 of the Stamp Act.
My lord is right.
No, not like section 3 of the Stamp Act.
Not raise the premise that it's not.
In all cases, it's not taxable.
That's right.
If it is not executable, if it's not been executed, because only on execution of the instrument that the stamp duty.
Not just that plot. Even section 3. Section 3 says certain instruments are not chargeable to stamp duty.
So I was suggesting, my lord, if your lordships could consider saying that so far as the stampability of an arbitration agreement is concerned, it would depend upon the facts of each case.
That's right.
That's good.
We're not going.
That's all. That's all you did.
That's correct. That's it.
That's all.
Volume 1.
Facts of each case, and that's why, my lord, it should be relegated to the tribunal. Now, my lord, the next. I mean, the submission is at page 29 of volume 1, where your lordship will find that. My lord, the next point is, short point, is that nothing can be said to be, of course, this has been made, my lord, by Mr. Datta, so I won't repeat it, but something which is rectifiable and curable, it's a temporary affliction.
Yes,
It would
that's
not, my
argued.
lord, that's covered. My lord, that is at page 12 of my note. Then, my lord, the issue of section 5 of the Arbitration Act also has, my lord, been
He has argued
he has
that.
argued it that it's a notwithstanding,
Yes.
non-obstanding, non. I've taken up also, my lord, in my submission, the point of complete code, that an Arbitration Act is a complete code by itself, and therefore there is no question of the Stamp Act coming in. That's it. Just give me a minute. my lord.
Yes.
Part 2, but part 1 can't be worse off than part 2, because part 2 is on the basis of this. So, my lord, That would be my
Thank you, Mr.
submission.
President. Thank
I
you.
try to be.
Thank you, Mr. Mr.
Next
Mr. Jain.
But your Lordships would find my written note of submissions in volume 1 at page 30. I'll be briefer than Mr. Sakhar Dande, my lord. Much of the canvas has already been painted. I do not wish to repeat any of the
Volume 1, page 30, right?
page 30. 30. But I have in my note referred to the paragraphs of the majority and the minority. Lord, whenever if Lordships feel, Lord, any assistance can be taken from there. Lord, I'm not reading or reiterating them. The points that I wanted to make, Lord, are the following, and I'll try and elaborate it, Lord. The reason why we take exception to the formulation of the mechanism in which the stamp duty is to be, my lord, collected, in the opinion of the majority of NN Global 2, what are the following? Not only does it not, in that classic sense, and please don't take me wrong, my lord, on this, in that classic sense that it really relegates us to a position where, for want of a horseshoe nail, the kingdom is lost. In the sense, my lord, it compromises on all timelines that the Arbitration Act contains and gives us, namely, my lord, Lordships will look at 11 subsection 3, subsection 13, where it says, my lord, within 30 days of the notice served to the other side, my lord, section 11 petitions to be decided. Section 9 contains a timeline of 90 days and so on. But all of this is a time-bound mechanism. That's one. And not, I'll leave this at that because this is an obvious point and I do not wish to not carry coal to Newcastle because it is going to not delay. Because, and another reason for which not we say it is going to delay is that under the Stamp Act, we have no mechanism of ensuring that it is in a time-bound manner. You just realize that. So in Garwari, your Lordships directed the stamp authorities to ensure that the stamping takes place in a period of 45 days. We have no data whether the stamp authorities really respected that, but not given the manner in which the revenue authorities function, it is very likely that they did not observe that 45-day window. As a result of which, making section 11 petition hostage to an undefined timeline under the Stamp Act and over which the section 11 court would have no jurisdiction, because the section 11 judge cannot direct the revenue authorities to do it in a time-bound manner or in a certain period of time. Why? Very often you may find that section 11 judge is not the same court as the court which would have territorial jurisdiction over the revenue authorities. Take, for example, seat and venue. Suppose an agreement is executed in Delhi, but has its seat of arbitration in Bombay. The Bombay High Court can't issue directions to the revenue authorities in the state of Delhi. And likewise. So you could have a situation where, my lord, you have an uncontrolled timeline consuming an entire process. In other words, for want of a horseshoe nail, you have the kingdom getting lost. That's the point number one, my lord. The second point that we have for your Lordship's consideration is, my lord, that this formulation also runs afoul, my lord, of the larger public policy principle. The larger public policy principle that your Lordships have seen in various legislations is that, my lord, entertainability of a petition is not made subject, my lord, to a fiscal precondition. But I hope I'm able to communicate myself. Entertainability of a petition is not made, my lord, subject to a fiscal precondition, except in situations where the legislature wants that to happen. And more often than not, those situations, my lord, are in the instances of appeals. I have in my written submissions given examples, and if I may very, very quickly, without taking Lordships through those provisions, if I may invite your attention, my lords, to paragraph 2.4.1, my lord. Just kindly see that, not at page 33 of my written submissions.
That as a broad proposition may be very difficult to accept.
No, I'm just taking a leaf out of that. I'm not saying...
Yes, you can treat it as an argument to support.
That's right. That's the highest that I can put it. I can't,
not as a...
No, of course not. I cannot not say that as a blanket rule, but I am giving instances where, wherever the legislature found that there has to be a fiscal mandatory precondition. And for this, I assume that an arbitration agreement, may be subject to stamp duty. But even then, section 11 contains no such formulation. And wherever, my lord, the legislature wanted, my lord, that fiscal preconditions to be, my lord, imposed, lordships would find that in those instances in 2.4.1. My lord, we have collated all of these, my lord, in volume. Sorry. 4C. My lord, volume 4C.
You're referring to central excise, surprise, etc.
That's right. And lordships would invariably find that those legislations use the word shall not be entertained, shall not be admitted. So, Lord, wherever the legislature felt that there has to be a fiscal, mandatory, inviolable, inexcusable precondition, Lord, the formulation is to be found in words like shall not be entertained, shall not be admitted, and so on. None of which are found, Lord, in section 11. Not even found in 9, not even found in 8, and not found in 45.
So the formulas say in the Customs Act, the
That's
Central
right.
Excise Act.
And all of those are at the
That
appellate
is
stage.
surprisy as well.
I'm so deeply obliged.
Your appeal.
I'm so
will be
deeply obliged.
maintained
And
only
all of
after
these
you-
formulations apply to an appellate stage when, my lord, there has already been an adjudication at the first instance. There is a finding of certain payments due and collectible, and then not that precondition is imposed. None of them provide at the first instance. And therefore, what it is not to say, because you are just counterbalancing the two acts. It's really a question as to, my lord, whether the Stamp Act should take precedence over the mechanism under section 11, or would your lordships leave the collection and adjudication of stamping and the duty, my lord, to the arbitral tribunal? It's a choice, my lord, between two competing legislations, and both of which are exhaustive courts. Stamp Act is an exhaustive court, and so is an arbitration. Both are consolidating acts. So therefore, in our respectful submission, the formulation by the majority falls foul, my lord, of this principle that where the legislature, and my lord, this is also furthered in some sense by section 36 of the Stamp Act. Lord Lordships saw that Mr. Datar, my lord, in his own usual, my lord, illustrious way, my lord, placed before your lordships, not section 36 of the Stamp Act, which says once it is admitted into evidence, it will not be gone into. So legislature, while not making a fiscal statute, itself was cognizant that you can have some instrument slipping through the stage of evidence, and then there is no question of putting the clock back, going back on the admissibility of that instrument. That's why, my lord, neither section 33 nor section 35 invalidate an instrument. They only say it will not be received in evidence. But, and section 36 says once it has been received in evidence, there's no question of unscrambling, not scrambled egg. The third aspect, my lord, in our respectful submission as to why, my lord, the majority's view needs to be, my lord, recalibrated, my lord, is, my lord, that the majority leaves, my lord, Mr. Trivedi pointed out, my lord, section 9, the majority does not go into para 169 of the judgment. Majority says we are not going into section 9. Now, but in our respectful submission, that is neither here nor there, for the simple reason, an argument that is, I'm sure, would be made before lordships, that section 9 should have a different test. But there is nothing in section 9 which gives any guidance to that argument, or which supports that argument. You cannot have a situation where, for the purpose of section 11, you have a formulation of a stamp duty first, entertainability later, for us purposes of section 9, a different regime. So, this is going to snowball, no, without a doubt, into a section 9 situation. This aspect of, first collect the stamp duty, get the certificate under 42, and then, entertain the petition is, with time, I'm sure, will snowball into petitions of section under section 9. Not section 9, as lordships have defined in numerous cases, is, our measure that are by definition
If something
urgent.
if something is void, then section 9 will also come in.
I'm so deeply obliged for the question. It is an agreement can be void only within the four corners of the Contract Act. The Stamp Act does not invalidate a contract. It only says it shall not be acted upon or would not be admissible in evidence. It does not invalidate. And therefore, even for the purpose of section 9, my lord, the test of 11, with greatest of respect, whether it is 8, which says prima facie, 45, which is now brought at par with 8, says prima facie. the same test would have to be applied. And Lord Lodges have in Vidya Rolia held that the test for the purposes of 8 and 11 are synonymous. It's the same test that apply to 8 and 11. Lordship, you just kindly note not the paragraphs with their role here, Lord. Those are 144, 145, 147.5 in Vidya Rolia. 144, 145, 147.5. I will give the page numbers also, but kindly bear with me for a moment. Your Lordships would find not 144 at PDF 189, 145 at PDF 190, 147.5 at 191 of volume 5A of volume 5A. Now, Lord, that brings me to another point within this, the second argument that I have, that the larger public policy, my Lord, is to not treat the fiscal requirement as secondary, but surely not something that precludes the any party or any person, my Lord, approaching the court. Now, Lord, please have with me, Lord, unfortunately, that is in another volume. Please have with me section 149 of CPC. (149) of CPC. Your Lordships would find that in volume 4A at page 727.
Volume 4A page
727, Lord. PDF 727.
Seven to seven.
727.
727.
No, volume 4A, I'm sorry. Volume 4A, page 727.
4A. 7 to 7.
My lords have it now. Now, I'm not. If a person does not go into the is not a party to an arbitration agreement, a suit would be the normal usual remedy. In a commercial matter, I'm not answering the description of a commercial relationship in terms of the arbitration, right? Not if there is no arbitration agreement, a suit would be the remedy. For a suit, not the court fees will have to be paid. Please see how CPC deals with payment of court fees. 149. And kindly see the language. Where the whole or any part of any fee prescribed for any document by the law for the time being enforced relating to court fees has not been paid, the court may, in its discretion, at any stage, allow the person by whom such fee is payable to pay the whole or part as the case may be of such court fee, and upon such payment, the document in respect of which fee is payable shall have the same force and effect as if such fee had been paid in the first instance. But a plaintiff moving the court under form 149 seeks leave of the court to say, well, for reasons A, B, and C, please allow me some time to pay the court fees. That does not preclude not entertaining the suit. That does not preclude not the suit court from granting an interim relief. So can we have an interpretation of the arbitration agreement, Lord, which puts a plaintiff in a civil suit in a better position than a petitioner under the Arbitration Act? Yet again, what Lordships find is the legislature saying there is a precondition, but it is not an inviolable precondition. We have ways and means of ensuring that, Lord, in a given situation, ends of justice are met, while the fees can be collected later. Lord, we also have in the CPC Order 20, and by the 1976 amendment to the CPC, Lord, 6A was brought into the CPC. Order 20, Rule 6A. Kindly have that, Lord. Your Lordship would find that at 793 in the same volume, volume 4A. Because I seek your lordship's attention to sub-rule 2 of Rule 6A, my lord. An appeal may be preferred against the decree. I'm sorry, my lordship's have it. An appeal may be preferred against the decree without filing a copy of the decree, and in such a case, the copy made available to the party by the court shall, for the purposes of Rule 1 of Order 41, be treated as a decree. But as soon as the decree is drawn, the judgment shall cease to have effect of a decree for the purpose of execution or for any other purpose. Once again, Lord, a decree would have to be stamped, would have to be drawn. But the legislature said you don't have to wait for expedition, for ends of justice. You can always have the decree being drawn in parallel, but the execution proceeds. Because it is not, we're not waiting. The legislature is telling us, please don't wait for a decree to be drawn, which would require stamping and proceed for execution. But yet again, another instance of the fiscal precondition, not for drawing of a decree being.
Many, Mr. Mehta, many such examples there. We are concerned with a very narrow compass.
That's correct.
Right? Getting into other issues.
I'm just giving you examples where, Lord, the legislature has itself told us that a fiscal precondition is not such.
We are really confined now to interpreting this statute. So.
I'm not inviting it. My only purpose was to support my argument with Lord Order 22 Rule 6A.
Mehta, we look at your other submissions.
I'm so deeply.
Thank you, Mr. Mehta.
I'm most grateful, Lord, for a very patient hearing.
Thank you.
Deeply obliged.
Yes, Mr. Banerjee. You want to hear Carol after? And Mr. Khambata, we just wanted to know, I mean, it's entirely your choice. Would Mr. Khambata like to argue for, because as the amicus, you can wrap up what, unless you have all decided in advance, you know, who's going to.
Give me half an hour, my lord. Most of it is covered in the written submission, so I'm not going to, whichever way.
All right, Mr. Banerjee, you complete, so that we.
My lord, there is obviously a sense of deja vu here, my lord, having argued this at some length, my lord, before 5 judges.
And you're not springing any surprises on us.
No. I am, my lord. I'm coming to the surprise in a minute. My lord, this is the second time that there has been a 7-judge bench in an arbitration matter. And the earlier one was in this very court, my lord, in 2005 in SBP, my lord. The reason I'm mentioning this is that both matters concern an apparently innocuous provision of the law, which is appointment of an arbitrator, which is usually only to be brought in when the parties fail to appoint somebody, or the institution fails, or there is some stopgap required where the court has to step in, really just to make an appointment. Yet, such a matter has come before this court on 2 occasions before 7 judges. My lord, it's why is a question that perhaps, my lord, will require a long debate. But I will show your lordships, my lord, a little bit of the history of Article 11, which is relevant only to the question before my lord, which is, it's a very narrow reference before my lord. 11, section 11, should the section 11 court go into stamping? That's the only question, my lord, which your lordships have to see. Or should it be left to the arbitrator? Obviously, my lord, the canvas is wide. My lord, the problem is that while answering such an issue, every sentence that your lordships utter in this 7 judges will have an impact on section 11. That's the reality of the matter. My lord, we have lived with SBP for 18 or 20 years. And even after the 2015 amendment, SBP, my lord, the ghost continues. It was relied on in Garware, which is squarely before my lord. And there is a very important passage in Justice Roy's judgment where he deals with, my lord, SBP. That's one aspect of the matter. So far as, my lord, the narrow question is concerned on 11.6a, my lord, elaborate arguments have been made. I will, my lord, I have in my index set out a structure as to how your lordships can look at section 11 and, my lord, the consequences of stamping, that it is obviously, my lord, the agreement is valid and not void. This is a matter only of admissibility. All that has been argued. I will show a few pages of items which may have been missed. That's all, my lord. But, my lord, before I do that, I'll just take 2 minutes more of indulgence, my lord, because it's a mindset issue. My lord, judges normally, as I understand, I don't have any personal experience, whenever a matter comes before a judge, there is an inclination, my lord, to decide. If there is injustice and injustice presents itself and somehow there is an issue, the judge will decide. My lord, the entire purpose of 11 is somehow to impose self-restraint in not deciding. There is a Lakshman Rekha, my lord. If your lordship sees the language of 11.6a, the word used is confined to the examination. There is a Lakshman Rekha. There is a very limited scope in which the court, my lord, a section 11 court is really, and I said this before, my lord, it's really not a court. In fact, your lordships earlier would decide section 11 with a single judge. That was the practice in this court. That was the practice in the High Court. It would all be decided by a learned single judge. And in fact, there was a judgment of Justice Bharucha, as your lordships will remember, of 5 judges in Konkan, Chief Justice Bharucha as he then was, which said that really all you need to see is whether the procedure has been followed and appoint. And that, of course, my lord, did not find favor in SBP. So, my lord, the practicality of deciding something in a court in some way defeats section 11. My lord, the way the two acts are placed. My lord, we have grown up with the 1940 Act. The 1940 Act has a provision in section 20 where you appoint an arbitrator with intervention of the court. Your lordships may remember long time ago this section was there. There the thinking was at the very first instance the court will intervene and the court will decide what is the scope of the reference, and all points would be decided at the section 20 stage and go on. My lord, the 96 Act is a complete about turn. Nobody is saying, my lord, this is something, my lord, which haunts judges. Nobody is saying that the court will not have the final say. The court has to have the final say. The last word, supervisory jurisdiction, has to be with the court. Arbitrators cannot be allowed to run riot. But, my lord, we are not at the last stage. We are at the first stage, at the appointment stage. So who has the first look and who has the second look? What has happened here, my lord, is instead of the first look being with the arbitrator at the section 16 or article 16 stage, slowly and slowly 11 jurisdiction is being, my lord, slowly and slowly, my lord, increased. And the burden is immediately coming on the court. And the whole purpose was that the burden should not come on the court. Any matter your lordships take of 11, whether stamping or otherwise, your lordships will issue notice, somebody will file a reply, they will say limitation, they will say this, that. Lot of court time, my lord, is taken. And the entire purpose of taking it out of the system on day one, which the institutions do. My lord, they appoint, it goes out. 16, you have your first shot. 34, you have your second shot. And ultimately, the court decides. So, my lord, please keep this larger picture in mind, because every sentence your lordship will say on section 11, 11.6a will have some impact, my lord, broadly. Every sentence, not only in re-stamping, will have, this is, I wanted to, my lord, make this submission at the first instance. Now, my lord, in this slide, I will just show the index to my written submissions and only show a few aspects that your lordships may consider. Please come to the written submissions, my lord. The written submissions start at page 45 of the first volume. Have my lords got the index? My lord, this, I've just put it in a structure, and most of these arguments, my lord, have already been made. 4 or 5 aspects I just want to highlight. My lord, first is the introduction. How did the reference come about? What were the findings in NN Global? What is the relevant issue framed, my lord? Then, my lord, what are the summary of the submissions? I'll place them at the end. Then, my lord, the Stamp Act. the relevant provisions, which Mr. Datar has mentioned, the relevant authorities. Now, my lord, here Hindustan Steel was mentioned. There are some very interesting judgments, my lord, Privy Council, High Court and the Supreme Court. I will come back. He is Stamp Act versus an Indian Contract Act. That also has been addressed in some detail, my lord, 2G, 2H, 2J. What I would submit are the errors. Then, my lord, Roman 4, international perspective. I want to develop this. I want to show, my lord, what is the basis of this article and how it directly impacts, my lord, this stamping case. Then, my lord, Arbitration and Conciliation Act at page 46, my lord, what is the history? What are the relevant paragraphs of the 246 law report? What did the high level committee say? And then, my lord, some judgments. And then, my lord, Roman 6, I have focused on Garware and United India Hyundai, because, my lord, that has been specifically affirmed by the Constitution Bench in paragraph 29. And, my lord, Vidya Zolia, actually now it has been clarified, and I have mentioned it in my written submission in Career Institute, that really the question was not there. My lord, your lordship will see that one page before I go back, my lord, to on my note. Your lordship just sees the Career Institute reference. Please come to page 108 of the written submission.
How long are your written submissions?
Sorry, ma'am?
How long are your written submissions?
Well, Lord, I thought that it is better to put everything down so that since we are, my lord, pressed for time, I have put everything down in writing so that it is there rather than only giving pointers. Please come to 107. I mentioned, my lord, Careers Institute, Educational Society. This judgment, my lord, this order came one day before Vidya Zolia. Had this come, perhaps, my lord, there would not have been any need to debate Vidya Zolia to great length. Sorry, in NN Global. So, my lord, this order had not come. Then the judgment was delivered one day later, and it has the scope of Vidya Zolia has been, my lord, explained in Career Institute. I am therefore, my lord, not going to really touch upon Vidya Zolia today. My lord, I want to just show my lords Garware, because nobody has yet, your lordships have not seen Garware, which is the sheet anchor decision on the basis of which the 5-judge, my lord, proceeds. So if your lordships are pleased to just see Garware. My lord, Garware is at page 33, volume 5A, my lord.
5A.
5. My lord, Garware is absolutely on the point where this court holds that at the section 11 stage, stamping is required. That is, my lord, the 2-judge bench. My lord, the reasoning in Garware, your lordship will just note the paragraphs 18 to 22 and 29 in Garware. 8 to 14 is the history.
18 to 22
and 29, my lord, these are very important. If your lordship starts with paragraph 8 to 14, that starts at page 46. Lord, 8 to 14 summarize the previous history, Konkan, Rani, SBP, and then, my lord, quote the Law Commission, etc., and the bill. And, my lord, it summarizes everything in one place. My learned senior, Mr. Datar, referred to paragraph 13, which has the statement and objects and reasons. But in one place, my lord, everything is being summarized. 8 to 14. The reasoning starts at paragraph 18, which is at page 54. 18 to 22 is the heart of the reasoning. It will be noticed from the aforesaid judgment that where an arbitration clause is contained in an agreement or a conveyance, different consequences ensue depending on whether the agreement or conveyance is unregistered or unstamped. The next sentence. It is settled. Again, my lord, SBP comes back in the picture. It is settled by SBP and Co. that Section 16 of the 96 Act has full play only after the arbitral tribunal is constituted without intervention of court under 11. My lord, this is harking back to the previous regime of intervention in court, intervention of the court, intervention without the court. My lord, this finding at paragraph 18 proceeds on the basis that SBP is good law, that moment something is decided in 11, the 16 jurisdiction, which is really, my lord, the wider jurisdiction of existence, validity, jurisdiction, is curtailed because a court, and no court, my lord, the Chief Justice or his designate, because that was SBP, has decided something in a mini trial finally. So how dare an arbitrator go behind a Section 11 order in a Section 16 situation? Now, that is the impact of the quote of paragraph 12, which is quoted in some detail here. And my lord, in that quotation of SBP, which is relied on by the two judges at page 54, if your lordships come to 55, somewhere in the middle, my lord, prima facie, your lordships have this, this is relevant because of, my lord, the model law commentary. Prima facie, it would be difficult to say that in spite of the finality conferred under subsection 7 of Section 11 to such a decision of the Chief Justice, the arbitral tribunal can still go behind that decision and rule on its own jurisdiction or on the existence of an arbitration clause. So, my lord, what SBP says is, because 11.7 says the decision of Chief Justice is final, 16 jurisdiction is curtailed, 11 binds the 16. Now, my lord, that is the basis on which, if your lordship sees, at the next paragraph, where is that one? Para 22, my lord. The finding on this this aspect. No. My lord, sorry, please come to page 56. In view of the law laid down by the 7-judge bench, it is difficult to accede to the argument made by the learned counsel on behalf of the respondent that Section 16 makes it clear that an arbitration agreement has an independent existence of its own, must be applied while deciding an application under Section 11. So, my lord, the 16 argument that all issues should go to the arbitrator is rejected in view of SBP. This is first finding. Second finding, my lord, 19, my lord, the finding is the Law Commission has not specifically referred to my lord SMS, but it has overruled, my lord, it has legislatively overruled SBP. Then, my lord, 20, then 22 is the second error, which is the para which has been confirmed by the division bench, which your lordship, constitution bench. Please come to para 57, page 57. When an arbitration agreement is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. No difficulty. We have seen how under the Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. Now, this is the error which has been, my lord, compounded by the constitution bench. Therefore, on a plain reading of so and so and section 2H of the Act, 2H, my lord, is set out above, which is, my lord, 2G and H have been set out, would make it clear arbitration would not exist where it is not enforceable by law. This is the second error. And the third error, my lord, is at 29, where Hyundai comes in. That's the third aspect your lordships may consider, which is at page 62.
Page?
62, running page 62. Here, my lord, the division bench relies on Hyundai. To say, my lord, this was a Scott and Avery clause case. I'll just read it. The judgment in Hyundai is important. What was specifically under consideration was an arbitration clause which would get activated only if an insurer admits or accepts liability. Since on facts it was found, insurer repudiated the same, though an arbitration agreement exists, so to speak, in the policy, it would not exist in law as was held in that judgment. When one important fact is introduced, namely insurer has not admitted or accepted liability. So, my lord, this is the understanding of Hyundai. There's a problem with Hyundai because Hyundai is, there are difficulties, my lord, which I've highlighted in my note. The clause is intact. It is just that the scope is limited to quantum and not liability. You can't say that the
Hyundai is
arbitration,
accepted, then accept.
it's an accepted matter to the, so there's a problem with Hyundai also. Likewise, in the facts of the,
Just one.
likewise in the facts,
Look at section that.
so, my lord, in fact, what happened in Hyundai, my lord, I put it in my notice. The learned single judge of the Madras High Court, she appointed an arbitrator saying that this should go to arbitration. This honorable court, my lord, following a pre-11-6A judgment, held that no, there was no dispute as to, there was a dispute as to liability. Hence, the matter should, my lord, rest here, and the 11 was dismissed. So, my lord, again, the problem there is that, so I have dealt with that in my written submission. My lord, what, on the basis of Hyundai, which is now affirmed by the 5 judges, and Justice Roy, my lord, takes the opposite view. On the basis of Hyundai, this is the third part of the ratio of this judgment. Likewise, in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law. my lord, to summarize on Garwari, my lord, 3 points on Garwari. One,
Just 1 second.
my lord, it resurrects SBP to curtail the Section 16 jurisdiction. It resurrects SBP, my lord. Section 16 jurisdiction is curtailed basis SPP and relying on Section 11(7). This is one. Two, my lord, and that is a point which has been developed in great detail by Mr. Datar. Two, it holds a non-stamped agreement to be non-existent in law. And three, my lord, it relies on Hyundai, which itself has its own, my lord, problems because it was an accepted matter case. It was a 3-judge bench. And my lord, there are issues with that judgment, and I have, my lord, spelt it out. Just to decide Hyundai, your lordships, there had to be numerous hearings, first in the Madras High Court, then it came here, then that was heard. So, my lord, this is exactly what is the entire idea is to take it out of the court at the first instance and push it to the arbitrator, and of course, my lord, ultimately supervise at the 16/30. So, my lord, this is so far as Garwari is concerned. My lord, Hyundai, I have said whatever I have to say. My lord, I will now go to just 2 pages on this issue of existence in law and stamping, and then, my lord, the foreign jurisprudence which has not been shown, and then I'll, my lord, sum up. My lord, 2 pages in the written submissions, your lordships will see, and something quite interesting. Please come to page 61. 59. This is following on from what Mr. Datar has already argued in respect of the Contract Act. That what is the intersection of the Contract Act and the Stamp Act? The lordships at page 59 been mentioned. Then at the bottom of 59, there is a mention, my lord, of the Privy Council, which affirms the Patna High Court. Page 59 of the written submission. Your lordships got 59? Volume 1.
Yes.
Titled Relevant Authorities. My lord, first there is Hindustan Steel, which was mentioned in the morning. Then, my lord, at the bottom of page 59 is the Privy Council and the Patna High Court judgment, which, my lord, I have quoted. Object of the Stamp Act is not to alter the terms of the bargain between the parties, protect the revenue by excluding proof of the bargain. This is so far as this is concerned. Then at page 60, my lord, there are a series of judgments which consider the Stamp Act in some detail in the context of validity. And out of these judgments, my lord, the second one, Gulzari Lal Mewari, all these judgments were considered by Justice Roy in his dissent, noted in the majority but not considered. Gulzari Lal Marwadi is important because what the judge there finds is that in England there are provisions which make where non-stamping actually makes an agreement void, unlike in India. So, my lord, he gives that example in Gulzari Lal Marwadi. Then, my lord, Purna Chandra Chakrabarti, Justice Bijon Mukherjee's judgment. And then, my lord, the most interesting one, which is the bottom of page 60.
The Pakistan
one. My lord, I will, it is very elaborate, but I will not read the judgment. He goes into the legislative history of section 33 and 35 from the 1890s and sets it out. But, my lord, I am not on the judgment so much as the judge. The person who delivered this judgment was a Parsi judge called Dorab Patel. He was destined to be he was their H.R. Khanna. He was destined to be Chief Justice of Pakistan. When Zia-ul Haq came to power, he was asked to take an oath of office. He refused and he resigned. So he could not become Chief Justice of Pakistan. In the Bhutto reference, three dissents, one of which main dissent was authored by Dorab Patel. So very learned man, my lord, barrister, he analyzes in great detail the interplay. This case, what had happened was, there was an insurance contract. In that insurance contract, which was unstamped, the matter went to an award. The award was sought to be enforced. The argument was made that, look, the initial document is unstamped, it is void. He said that cannot be the law, that is a valid document, and there are some very interesting passages, some purple prose, if I can put it, where he uses very colorful language and he analyzes this. Your Lordships will certainly read this judgment, if only for that and for the background. So, my lord, the consistent position in all high courts, in the Privy Council, everywhere else is the fact that mere payment of stamp duty, my lord, does not invalidate the bargain. In fact, the way he puts it is, my lord, the object of the legislature was to protect public revenue and not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. And then he said it would be against all canons of construction to enlarge the meaning of the words in 35 so as to render invalid instruments which fall within the mischief. So, my lord, if the majority view in NN Global is to be sustained by this court today, forget arbitration. Anybody can turn around and say at any point that this agreement is void, this agreement is invalid, I won't do anything, whatever benefit I've got. In fact, my lord, we had also cited before the 5 judges a Privy Council judgment, my lord, which explains that if you take this sort of extreme view, then there will be all sorts of, my lord, practical difficulties. And Mr. Datar mentioned the quotation, my lord, from Mullah. We had also cited, my lord, the 13th Law Commission, where this problem was addressed. I'll just show, my lord, that passage from the 13th Law Commission, which is mentioned in the note itself. Presided over by Mr. Setalwar, where he deals with this particular issue specifically. Lordships will just see page 64 of the written submission. '64, my lord, refers to Mahan Singh, which is the Privy Council, and then Lord, please see page 65. This very question was raised about unenforceability. This very question of stamping and unenforceability was raised and shot down, and the law was summarized. My lord, at page 65, all these documents, my lord, are on record. We've given the volume and the page where it is there. The above judgment was relied upon by the Law Commission in its 13th report, chaired by MC Setalwar, specific context of an unstamped agreement, while dealing with a recommendation as regards section 2G as follows. Director of Legal Studies has also made the suggestion it should be provided in section 2G that agreements of imperfect obligations are not void but only unenforceable. He has mentioned an unstamped agreement as an instance of such a case. Such an instrument, which is a record of an agreement, is neither receivable in evidence nor can be acted upon. See section 35 of the Stamp Act. Since the decision of the Privy Council in Mahan Singh versus U. Babi, which I quoted there, the law is well established that the expression unenforceable by law, which is what is in 2G, does not mean unenforceable by reason of some procedural regulation, law of limitation, but unenforceable by reason of substantive law. In view of this, it is unnecessary to introduce the suggested change. So, my lord, 2G is restricted to unenforceable by law, which, as is explained, is void. So, my lord, if an agreement is void, null and void, that stands on a completely separate footing. My lord, we are not going into existence or validity here. My lord, we are on admissibility. So, my lord, this is so far as this aspect is concerned. In this background, I would like your lordships now, just before, my lord, I come to the summary of my submissions, to just see the model law and the commentary, because that has some, my lord, impact on this. So, my lord, the model law, Article 11 of the model law was basically incorporated by us in section 11. And your lordships will recollect, I mentioned it a little earlier, that SBP seems to suggest in the majority and is disagreed by Justice Thakkar in the minority, that because 11.7 says a decision by the Chief Justice is final, that means nobody else can look at it in 16. But the intention actually in the model law was exactly the opposite. This expression final and no appeal has been explained. Lord, there are two commentaries on the model law which are of relevance. My lord, one is a book by Peter Binder. We have put the extract. My lord, Peter Binder very conveniently collects all the foreign law on each of the articles. And there is a second book by Holtzman and Newhouse, which we have put, also extremely convenient, because the entire discussion as to the Trabo is set out in Holtzman and Newhouse. I know my learned friend, Mr. George Pothan, has individually set out the entire thing, but these two books actually summarize the entirety. And I will just show 4 pages of that.
Where is that? Where we refer to these two?
My lord, the first one, if your lordship sees Peter Binder is in volume 4B at page 4393. I hope I've got that right. Serial number 7. Volume 4B, 4393. Interestingly, my lord, today I'm citing the 4th edition. The 2nd edition was cited in SBP, but not noted. 4393. Has your lordship's got 4393? International Commercial Arbitration and Mediation in Ancestral Model Law Jurisdictions.
4393.
In fact, your lordships will find there is not much case law, because nobody other than us has a problem in appointing arbitrators. And my lord, there's a reason. Have your lordships got 4393? Yes. My lord, 4394 is where the model law is set out. Please see Article 11.5, because this will become relevant later. No? A decision on a matter entrusted by paragraph 3 or 4 of this article to the court or other authority specified in Article 6 shall be subject to no appeal. This is where we get our finality provision from. The court or other authority in appointing them shall have due regard to qualifications. So, this is the source of our 11.7 of finality. Now, why did this come is made clear, my lord. If your lordships go down a few pages to 4398. It starts at 4397, default procedure, 4398, paragraph 6. Two very interesting sentences at the bottom of 4398. The finality of a court's or other authority's decision in this case is essential to the rapid constitution of the arbitral tribunal, as was pointed out by the analytical commentary. I'll show the analytical commentary. The next sentence is even more interesting. It is suggested that this provision does not infringe on the procedural rights of the parties because the possibility of applying for setting aside of the award according to Article 34(2)(a)(4) of the model law remains open. So finality, the purpose of finality is really to make sure that the procedure starts, because the arbitration should start. Then, of course, the court has the right. Chalo. paragraph which I was reading, please see the Act. Your Lordships are very familiar with the Act. My Lord, in 8 there is an appeal. In Section 8 there is an appeal. In 9 there is an appeal. In 17 there is an appeal. Even in 16 there is a part appeal. In 34 there is an appeal. In 45 there is an appeal. Only in Section 11 is it that there is a specific no appeal. And the reason is, my lord, for this reason. Because in every other situation, the court, my lord, is a 2-1E court. In an 8, your lordships will have to apply mind as to whether it is a suit which has to be stayed, what are the prima facie grounds, etc. 9 is interim relief, there has to be some prima facie case. 16 jurisdiction, if it is, my lord, allowed, there is an appeal. 34 application of mind. 45 there are some grounds. But 11, the statute says, 11.7 of our statute says no appeal. And the reason is this. Finality, my lord, is in the context that you get the cart rolling. So that 16, my lord, there is a lacuna in our statute that in the model law, there was an appeal from 16. The reason why there is no other jurisprudence of any consequence abroad, and my lord, I'll show that, is because all these issues, stamping, this, that, everything goes to 16. There's a straight appeal in 16 before the 34. So you don't have to suffer the whole arbitration. But that's, my lord, a legislative lacuna which may perhaps be addressed, my lord. So, my lord, this is the passage here. Finality is essential to the rapid constitution, and then, my lord, there's a footnote. The footnote refers to the analytical commentary, which I will show. And the suggestion by Peter Binder is the reason that this does not fall foul of parties' rights is because you have a later challenge. Justice Thakkar in his dissent uses the phrase chronological priority. My lord uses the first look and second look. First look with the tribunal, final second definitive look with the court. Nobody's running away, my lord, for that. So, my lord, this is one passage I want to show. The second one is the, my lord, in this, if your lordship goes one more page at 4399, cases clout. So, all the cases under the clout system, Article 11, my lord, and there is not much law because this is really not debated. This is not a problem. This is a problem peculiar to our act and our jurisprudence. So, my lord, those cases are there. Please leave that. Please come now to the relevant portion of the travaux préparatoire, the model law. My lord, please come first to page 4363, same bundle. 4362 is my lord, the title. This is, everything is in one place. A guide to the ancestral model law on international commercial arbitration, legislative history and commentary. Howard Holtzman and Joseph Neuhaus. My lord, this in the next page gives the article. I don't want to, my lord, read the entire thing, but it is essentially a default clause. It's a stopgap. Please come to 4386. 4386. Seventh Secretariat Note, analytical commentary on draft text ACN 9/264, 25th March 85. My lord, this has been separately annexed also, but it is here. And in this, would your lordships come to para 7, which is at page 4387. This is, my lord, what is quoted. Rules and guidelines for decision of court, paragraph 5. According to paragraph 5, the decision of the court shall be final whether it relates to a matter entrusted to it by the court by the suppletive rules of paragraph 3 or by the mandatory provision of paragraph 4. In cases where an agreed appointment procedure fails to secure the appointment. Finality seems appropriate. Lord, these are the words which again take us back, my lord. In view of the administrative nature of the function and essential in view of the need to constitute the arbitral tribunal as soon as possible.
As you said, to get the cart going.
This is to get. So, my lord, the entire purpose of Article 11 was only appointment of arbitrator and leave everything else by and large to the 16 jurisdiction. So my lord, this is the international, this is the basis on which we have our 11.7, which uses final and no appeal. Same, my lord, the same portion is used in 11.7. So my lord, this is something that your lordships may keep in mind, because in Gadware, the two-judge bench specifically refers to that portion of SBP, and on that basis curtails 16 and says that 11 has a wider play. So, my lord, it squarely applies, and this aspect has been dealt with by Justice Roy in his dissent in 4 paragraphs, which I will show, my lord, and then I will just summarize my submissions my lord, in 2 pages. Your lordships may just see the dissent of Justice Roy on this aspect. The earlier portion. No, on SPP. Let me come to page 492
Volume number?
of volume 5A. Just a minute. Just your lordship, just give me a second.
What page?
492.
492.
One. Not that. Right at the beginning.
Para 455.
Yes. Mulon may come to page 458.
458 or paragraph 458?
458, Mulon, of Justice Roy's
Paragraph or page number?
page number. Page. Volume 5. 5A, my lord.
458.
5. My lord, 5A, 457, he is discussing SBP, and 458, my lord, he starts discussing the dissent at para 353. And he gives, my lord, he summarizes Justice Thakkar's dissent at 354. Firstly, the function of the court is to interpret the provisions as it is and not to amend, alter, substitute the interpretive process. Secondly, it's for the legislature to make a law applicable to certain situations contemplated by it. Judiciary has no power entering into legislative wisdom. Thirdly, as held by me, the decision of the Chief Justice is merely a prima facie decision, and subsection 1 of section 16 confers express power on the tribunal to rule on its own jurisdiction. Fourthly, it provides a remedy to deal with situations created by the order passed by the arbitral tribunal, emphasis in original. Then a sheet anchor of his decision is in the guise of interpreting statute, judicial legislation not permissible. And then 355, he then considers section 16 in some detail. And then 356 is the conclusion in the dissent. The above line of reasoning in Thakkar J's dissent resonates with the internationally recognized principle of competence and the doctrine of separability. Majority opinion SBP suggests section 11 could conduct a mini trial at the pre-referral stage, which is where, my lord, we are heading again. Jurisprudential correctness of SBP has been doubted and was considered as excessive judicial intervention. It has been legislatively overruled by subsequent amendment. So, my lord, he finds SBP is gone, and there are a number of, my lord, observations thereafter. The majority still and the concurring jurisdiction of Justice Ravi Kumar still relies on SBP. Garware still relies on SPP, my lord. That ghost is still there. Because, my lord, we feel, or judges feel, that where there is some injustice, even at the 11th stage, there is a, my lord, inherent desire to correct the wrong. But in correcting that, my lord, wrong, what the balance is, that wrong could equally perhaps be corrected by somebody else without taking up. My lord, today 7 judges are sitting on an arbitration matter which really should be somewhere else before somebody else deciding a 16 on stamping. So, my lord, that was, my lord, what the dissent, my lord, specifically affirms. So, my lord, these aspects your lordships may keep in mind while laying down the parameters of 11 in its totality, and in particular 11.6a, which is the language is, my lord, absolutely clear. My lord, another interesting thing. In the majority judgment, in the 5 judges, there is no place where 11.6a is quoted. Confined to the examination of the existence of the agreement, each word has been paraphrased, analyzed in great detail by Justice Roy. That expression, that provision is not quoted in the majority at all. So, my lord, whether on the text or the context, admissibility issues at least should not be touched at the 11th stage. Now, my lord, in that light, I just want to conclude by reading or placing 2 pages of the written submissions which summarize whatever, my lord, there is. Please, there it is summarized at various places. Your lordships will come to page 54 of the volume 1 written submission. It's just 2 pages, my lord. I'll just place it. 54 in volume 1. Anything else? The majority view in NN Global, the unstamped agreement is void, does not exist in law, does not lay down the correct law. Such a view is contrary to the provisions of Stamp Act, settled jurisprudence. In so concluding, majority judgment failed to deal with the several authorities cited before it, including, my lord, all these authorities which I mentioned, stating that an unstamped agreement does not render it invalid or void. Then, my lord, 2 is, it is a fiscal enactment. It is not a weapon of technicality. 3, my lord, I have taken from the judgment of the Supreme Court of Pakistan. Object is to protect public revenue, not to interfere with commercial life by invalidating instruments vital to the smooth flow of trade and commerce. 4, my lord, it's a curable defect, merely proscribed document from being admitted into evidence. 5, my lord, again, does not affect the validity of the transaction, merely renders the document inadmissible. 6, my lord, is important. Parties which have acted upon contracts substantially perform their obligations under such contracts insufficiently stamped will be visited with severe, drastic, and unduly harsh consequences. If an unstamped agreement is deemed to be not existing in law and or to be void, particularly true in cases original agreement is not traceable. Then, my lord, 7 is widening of the scope of arbitration agreement. Then, my lord, page 55. 11.6a language confined to the examination of the existence. Investigation of aspect stamping contrary to the plain language, contrary, my lord, also to the statement of objective and reasons, which says please don't go into other issues. Then word confined has a specific meaning, my lord. This was quoted by Justice Roy in his judgment that it's a Lakshman Rekha, you have a limit. Then, my lord, what I have submitted is existence has a specific meaning, should be restricted to existence and validity at the highest of the arbitration clause. Validity would mean arbitration agreement not null and void. It should be restricted to formal validity at stage of contract formation. Inquiry should only be to satisfy agreement in writing, core contractual ingredients fulfilled. And in any event, 12, by no means should it be extended to whether document is inadmissible as being unstamped. Inadmissibility and invalidity, my lord, whichever way we look at it, are different legal concepts. Lack of stamping is admissibility. And then, my lord, I mentioned 2015 amendment, and it is not turning a blind eye because, my lord, the arbitrator can look at it. And 16, even if your lordships under 11 appoint an arbitrator, the section is clear. 33 and 35 make it clear. Arbitrator is an authority under 33. He can look at it. He is looking at it, my lord, in all institutional arbitrations, in all other ad hoc arbitrations where there is consent. As an arbitrator, I have also been confronted on the first day with an unstamped agreement. One has to sort it out in whichever way possible. And, my lord, ultimately, there are a lot of 2 and 3 judge benches. Sometimes it is difficult to reconcile them, but your lordships have the luxury of sitting in 7. And if there are some portions that can be ironed out, I would request, my lord, this is an opportunity. After 18 years, my lord, it is not often that one gets a chance to raise an arbitration issue before a forum, and every sentence of my lords in the context of appointment of arbitrator will have some impact. It may be that 2019 amendment may be notified. It has not been notified as yet. But there is some rethinking on some aspects. Ultimately, whatever your lordships say, will have an impact not only, Malone, and I'm making, and I think I can make bold to say, not only on the stamping aspect, it may have some impact on other Section 11s. And I conclude by, Malone, mentioning a judgment of my lords, which shows that there are 11s pending from 2006, 2010, 2012. And Malone, the reality is it is really like a mini trial. You file the application, other side comes, he files a reply, you file a rejoinder, then there is a full-fledged hearing in the High Court, then there is an SLP, then your lordship sometimes, and the reality is that out, and we made this calculation, maybe in 8 or 10 matters, my lords have closed the 11. In the vast majority of matters, their appointment has been made and the matter has gone on. So, Lord, it is also a question of balancing judicial time and the legislative, Lord, intent and keeping it out of the system at the first instance. Nobody is saying it will not come back. Everything somehow at the 34th stage or somewhere may come back. But, Lord, that's the larger issue. So I'm deeply obliged.
Thank you, Mr. Banerjee. Yes, Mr. Kambata.
Okay, my learned friends would leave me about 45 minutes, but they seem to have left me 5 minutes.
But Mr. Kambata, we can give you a little time tomorrow. No difficulty.
Only going to
Yes,
if
absolutely.
your lordships are kind enough for that. My lord, I will of course not repeat anything, and I want to also place before your lordships a perspective not only under Section 11 but also private appointments of arbitrators and institutional appointments. Because I think, as my learned friends have said, 7 judges do not sit often to hear an arbitration matter. It's best that these matters are also ironed out by your lordships, because otherwise, my lord, other matters will float up the stream to your lordships subsequently. There's no point in that. Your lordships are fully seized of all the issues. It's best that your lordships lay down the law emphatically now, my lord. But I think Justice Khanna actually encapsulated the issue before my lords when all is said and done. And I believe Justice Khanna said whether non-stamping or understamping of the main contract can render the arbitration agreement void or invalid. That's really the heart of this debate. And I would request my lords to hear my arguments with 1 or 2 overarching thoughts, my lord. The first thought is that ultimately the Stamp Act is a means to secure revenue for the state arising from the stream of trade and commerce. The Arbitration Act assists the stream of trade and commerce, and any roadblocks at the initial stages will only dry up that stream. So to use stamp as a gateway dispute to arbitration really defeats the purposes of both acts. Today we are talking about making India a global hub for arbitration. And we have before us Section 5 of the Act, which has already been shown to my lords, as well as the fact that the Arbitration Act is a complete code. And I think taking all these together, I want to first give your lordships 3 reasons why the issue of stamp must be left to the tribunal in the first instance. There is always a 34 court. There is always a second look. And as my learned friend said, the first look, should it be just a prima facie look? Should it be a look at all? Or should it actually decide the matter at the outset? Now, there are 3 broad reasons why I commend, my lord, that your lordships purposefully interpret the provisions of this act to hold that the matter must be left to the tribunal. The first, and I'll go through it very briefly because my lords have expressed some view on that already, is the doctrine of separability. I'm conscious of the fact that under Section 16, that doctrine is incorporated for the purpose of the tribunal deciding its own jurisdiction. But it's not only under Section 16 that we find the doctrine of separability under our Act. We have it in black and white in Section 7. My lords, just see Section 7 for a moment. 7 subsection 2, which draws the distinction between an arbitration agreement, which may be in an arbitration clause, and the main contract. Not, may I continue tomorrow?
Half an hour to 45 minutes tomorrow.
I'll try and complete.
We'll be here at 10:30.
Very grateful to questions.